with names. That is, my lord, IA 171058 of 2024, dated 2nd of August 2024. And in this, my lord,
Yes, please.
my lord, in that, my lord, your lordship will find that each of these four categories, my lord, under each category, my lord, we have given names in the annexures as to what is the nature of the my lord, irregularity which has been noticed
Okay, okay,
as per
okay, yes.
Millard, that 24th January is not
I
our
thought you are paying for the board?
SSC, Millard, is the commission. We are, Millard, the recommending examining body, the recommending authority. Results are given. Now,
But
and Millard,
then it's very strange. One thing is very strange. That people who are not even recommended or who are not qualified, how did that happen? They were issued letters.
Millard, those are the irregularities, Millard, which have been documented.
That's,
So-
no, I know, but that's very strange also. I can understand manipulation in the results and that leading to, letters of appointment.
Millard, We are not
But
here,
in
my
this
lord.
case, it's more than that, even when they were not.
My lord, we are not here to defend that one. My lord, they are in custody. The persons who are involved are in
Money
custody.
goes up to the education
We
minister.
we are not here to defend that. We are trying to see, my lord, whether we can save.
But all the same, it's a very, very serious thing.
Very serious.
Of course, it's a serious thing, my lord. They are in custody, my lord, today.
Okay, yes,
Now, my lord, my learned friend is just telling me, my lord, that 24th of January is not our affidavit, my lord. That your lordship has.
Letter.
It is a letter given in response to an RTI.
correct.
And there, my lord, we were relying on the data which was lying with NISA. my
You
lord.
say it's in our database,
Sorry, my lord.
in your database.
My lord, because, my lord,
So you are now identifying with Pankaj Bans.
no, my lord, we are not identifying. But, my lord, they were the people who were doing this particular part of the job for us.
This was re-given.
No, we don't.
That's
My lord,
incorrect.
it's
Let me
very,
put
very,
it-
if it is
Your
necessary.
misstand can be, it's incorrect
My
information.
lord, no, my lord, kindly, let me just make one, my lord, statement to your lordship. Every individual case that your lordship wishes to go into, my lord, I will give an answer. Because there are several situations where, my lord, something is given and then later on it is
No,
re-asked for, it's
The
re-given.
difficulty is this,
Yes.
what is weighed with the High Court, we're
Yes.
not saying one way or the other. What is weighed with the High Court is, we cannot even database. Whether it's reflective of the true OMR sheets, and there are indications
My lord,
and factors into account which create doubt about the original database.
so, my lord, correctly. My lord, but the High Court, my lord,
Whether they're
has,
right or wrong, that's something for us.
but my lord, the High Court does in fact accept the CBI report.
No, it doesn't. It uses that as a basis. TBI report is limited to the effect that there's a mismatch between the appointments and the database.
No, my lord, numbers also.
If mismatch means all that.
Yes. So, my lord,
But-
CBI
but the-
also is proceeding against.
CBI CBI has not been able to ascertain and go into the question because there, in criminal matters, the benefit of doubt is available, proof beyond reasonable doubt is a
Lord,
present.
all that will come later
Civil
on.
matters, here we apply the principle of probabilities, which is very different.
However, my lord, at the end of that
That is
exercise,
different.
my lord, what I am submitting is, at the end of that exercise, there will still be a large number of persons, my lord, around 25,000.
Only question which you have to answer.
Yes,
If we get the answer,
yes, my lord.
that the database which was available
Yes.
is the actual authentic database of the OMR sheets or not, we'll be able to
My
ascertain.
lord, that the CBI says it is the authentic database, my lord.
Cannot.
My lord, your lordship will.
They have not been able to ascertain that. They have left it blank.
No,
They have left it neutral.
that's the basis of saying, my lord, actual.
They have left it neutral.
My lord,
Because, and that's a role of an investigating agency.
yes.
Because where they're not able to ascertain it, because they could have only ascertained it on the basis of original OMR sheets. There they have not been. But I'm still worried about blank OMR sheets question, whether that's correct or not.
That's correct, my lord. That's documented.
My lord,
Whether if you have a blank
my
OMR
lord,
sheet,
it is not enough to.
then the possibility of change of OMR sheet.
No, my lord, there is no such case. My lord, let me just indicate one thing, my lord. Suppose there are blank OMR sheets, my lord, in the scanned copies. My lord, what is the marks which have been given to that?
No. Then when we'll know from the other side, we'll.
Yes,
Yes,
it's not enough to say there is a blank sheet. It must be shown that that blank sheet led to somebody getting 100 marks
Correct.
and my lord, getting appointed.
Yes.
Just one second.
Then we'll address after the board.
Please, my lords. I have here for the board with my learned friend, Mr. Sanjay Ghosh, my lords. So this was a Mahabharat which required two Sanjays and I see a third.
No, that's not the way. It's.
Please, minutes. Well, your lordships is grappling with the question of whether things can be desegregated, whether it is absolutely necessary to throw out everything, or is the data in such a shape that it would support the CBI case? Because ultimately, my lords, if your lordships were not to accept the data, then it would also probably impact the CBI case. So we have
No,
to
no, no,
proceed-
please.
We have to proceed
One
on the
minute, one
basis.
minute, one
We
minute.
have-
One minute. I think you are basing your case slightly differently.
Please, my lords.
Who's argued till now says accept the CBI data, but on the basis of the CBI data, don't throw everybody out.
Uh,
Segregate and apply the CBI data and
Yes,
segregate,
yes,
that's
yes.
the case.
That's the same thing.
Are you
I'm
making a
also
different
saying-
case?
I'm also saying the same thing. I'm also saying the same thing.
That's the way everybody's argued?
Please, my lords. Please, my lords. And like, based on the CBI's own written submissions, my lords, I thought we should do a reverse exercise.
Look,
How much
as I
is
said,
untainted?
100, please. Mr. Hegde, the civil matter is slightly different from the criminal matter.
I take it. I take it. My,
And the standard of proof, the principles of proof are intact. So the question, findings recorded by the High Court proceed on the CBI findings, but they go beyond that.
Please, I take it. And my lords, I have a limited role in as much as I made almost all the appointments based on recommendations from the commission. There are a few cases which are not on recommendations. That's the allegation. That's a separate thing. My concern, more than the jobs, is to have continual education in the state of West Bengal.
No, you can't.
I'm
I'm sorry, Mr. Hegde, we will not permit that argument to be made for the simple reason, in case either we accept the judgment or we accept your proposition that it's possible to segregate. Third argument, that this education is to be provided and therefore ignore that.
I'm not asking your lordships to bless everything. Let me put it that way. I'm not asking for a
Don't
total
raise
absolution.
that
But I just want to bring the consequences. And my lords, first let's see what is the nature of the problem. If your lordship can kindly take the chart which I've handed over.
It's tiny.
This is as per the CBI's own data, my lords. Now I've segregated it according to the posts. Now, as far as the assistant teachers from the 9th and 10th standards are concerned, the CBI data when totaled up comes to 979 out of 13,056 vacancies. So the untainted in the 9th and the 10th is 92.
This includes the additional ones also appointed?
Please, my lords, everything.
This includes the additional ones who are
Please, ma'am.
appointed or without the additional ones?
All, based on the.
No.
So therefore, my lords, the figure of untainted appointments is as 92% in the 9th and 10th. As far as the assistant teachers for the 11th and 12th are concerned, untainted is again just 5% less, 87 in 0.31%. So there are 730 vacancies. The real problem arises in Group C and Group D. And there, my lords, the untainted as far as Group C is concerned is 52 and Group D is 49. They are all identified, my lords, and it is to that extent it is severable. My lords, I take your lordship's caution about the consequences, but may I venture to state, my lords, that recruitment of teachers, there's almost no state where there haven't been problems. There haven't. I've appeared in cases from Uttar Pradesh, and I don't want to perpetuate. I don't want to perpetuate, my lords. I come from a family of teachers. I understand the problems of having bad teachers. But here, where the majority is 92% and 87% who are untainted, who have got a job. At this stage thing, that may be a bit harsh, my lord. So therefore, where a segregation exercise is demonstrably possible, then please, my lords, Mr. Ghosh is right when the last recruitments are 2016. We are in 2024, and if we were to restart if the commission and everybody were to restart the exercise after this, there would be we also have the attrition factor of retirements, resignations, and all that. So, please, my lords.
Okay, that's all. Yes, please.
Please, my lords. Yes, and then that was one administrative thing also, my lords. The academic year for this year, February exams start, board exams, so it's after May or someplace. When the process for this year begins.
You please tell us you are paying for class C and D or teachers?
My lords,
No, others. You are paying for everybody.
I'm sorry.
Yeah, for
I beg to appear for the petitioner in item 1.4.
No, you are C, D, which class are you?
Group 9 and 10 and Group C.
Group C.
Group C,
52%.
one candidate.
52.77%.
I am appealing for some
No,
kind.
what happens is, half is gone.
Let me start with
I don't know whether दाल में काला है कि सब कुछ ही काला.
my lords have very prettily put the issue. The important issue is in regard to the very authenticity of the documents which have been relied on. This Honorable Court on 9th November passed an order which required the authenticity of the documents to be seen. 9th November 2023.
By 65B.
The matter goes back and at page 900 of the compilation on 19 January proceedings, the division bench notes that this is the issue which has to be gone in Supreme Court direction. The CBI sends the documents for verification to CFSL. CFSL sends a report that they are not able to look into the authenticity of the documents because they are too bulky. This is noted in the proceedings of 24 January 2024. On 5th February, an affidavit is filed by CBI under section 65B and a status report is also filed in regard to documents which have been seized on September 16, 2022. This certificate
65B.
had not seen the light of day from September 16, 2022 till 5th February 2024. In spite of several days of arguments in this Honorable Court where Mr. Patwalia had appeared and the matter had, at no stage any of these had been produced. Now, the division bench of the High Court says Article 12 authorities have accepted the authenticity of these data furnished by CBI and they are not questioning it. We, the affected candidates, were never given an opportunity to see even these documents. One day,
No, this is wrong.
No, that's incorrect.
Look, we will not go into this way of line of reasoning for the simple reason. In a writ petition, you need not, in a case of this nature, candidates will become impossible, unavailable. Everybody knows about the litigation. If they want to come forward, they can come forward. We'll not permit that. We'll not go into that. There has to be some class action litigation where we apply order 1, rule 8 and proceed accordingly. There's going to be some limitations on that, on applying the principles of natural justice like that. Anyway, we are hearing you.
These affected candidates, no, should be given some opportunity at some stage. Please see, when the dishonorable court specifically directed this to be gone into, how the High Court has approached
This
this.
will be very difficult if we accept that otherwise we'll have to make all 22 lakh candidates a party.
No, but not 22 lakh candidates. It is only in respect of the appointed candidates. Selected and appointed. No, but our appointment cannot be set aside.
Our Babu, etc., take all that into account. They say either review or revision. That's the right view. He'll follow.
No, today the situation is there is a
Please argue on the
prosecution.
merits. Please argue on the merits. We're not rolling the wheel backwards.
My respectful submission is there is no finding by any authority, independent authority, in regard to the authenticity of the document. It is because persons who, according to the petitioners, have been involved.
The facts on record are very clear. That's why we went very slowly when it came to the facts. The SSC, there's some affidavits say that we have the record, but they now say that they did not keep the mirror image. One. OMR sheet, physical forms, not available. OMR sheets were scanned and also checked and evaluated in the office of the SEC. But they did not keep the hard disk with them. The hard disks are found with two other places. They are matching. How did the two develop? Whether they were done simultaneously, what happened, we don't know. CBI will tell. There is also indication that the marks available on the, as per the OMR sheets on the hard disk, and the marks available and allotted to the candidates as per the of data available with West Bengal's commission are different. Now, it raises another question.
That's my song.
Whether there were another OMR sheets which were clearly reflecting the same marks as the OMR sheets, as the 65B certificate, it serves no purpose. Let me put it, 65B certificate, it only says this is the hard disk. That's all.
Or this taken away by an employee to his private residence.
That's all.
And not recovered from the place where it
No,
should have
it's
been.
not even recovered from the company which was given
Correct.
the task. So that's all the more serious.
Then in which case,
It dents the whole case. It in fact dents the whole process of recruitment itself.
no, but the conclusion that it is tainted cannot be arrived at on the basis of the tainted evidence. Come to the conclusion that the examination or selection is tainted. With the greatest respect, what my lords have pointed out shows that the evidence is not authentic. If the evidence is not authentic, one can't draw a conclusion that the appointments are bad. The entirety of the appointments are bad. But that will not, with the greatest respect, will be doing injustice.
Is a double sport which may hurt you.
I'm sorry, ma'am.
The argument that you are raising.
Prosecution has been initiated. The case, authenticity of documents, etc., are all to be gone into there. Today, this conclusion which has been arrived at on the basis of which our appointments have been set aside on a wholesale manner, that cannot possibly be substantiated by this kind of evidence. That is a matter which is going to be gone into in the prosecution. Kindly, therefore, avoid that. Do not go ahead. Otherwise, I will demonstrate how these the authenticity of these documents have not been established, and therefore, on that basis, please do not uphold. High Court, in my respectful submission, has failed to carry out the mandate of this Honorable Court's directions of 9th November. That is the principal submission that I want to make. Therefore, this is a matter which needs consideration on that account, I want to show those.
Okay, show us the 9th November order.
Yes,
and the order
page
passed by the-
734.
And the report of the CBI.
Yes, page 734. 734, I believe, middle of the common compilation. Yes, volume 3.
9th November.
Yes, please.
Let this, honorable bench of this honorable court, after hearing substantially, kindly have a look at the order pass at page
What is the date of the order? 9th,
9th November,
November 23.
9th November
2020,
2023.
23. Yes, please.
Yes,
Go down to the relevant portion.
I'm sorry.
Go to the relevant portion.
Yes, relevant portion, para 5. Main argument, so far as this batch of proceedings are concerned, have revolved around the admissibility of certain scanned copies of OMR sheets. The High Court found.
No, this is not required. To be very frank, 65B certificate is not really the main question.
No, I'm not even on the.
Come down to the.
I'm not even on 65B certificate. I'm on authenticity. High Court found substantial difference between the evaluation records lying with the authorities and the performance of the candidates reflected in these scanned OMR sheets. CBI claims to have recovered the pen drive from an. At that time, the argument was about a pen drive. Today, it's completely different. Pen drive from an ex-employee of the agency, which was entrusted with the task of evaluation of the OMR sheets. Employees whose services are sought to be terminated questioned the authenticity of these scanned images, and it is also the case that
Look, this is a government bait because CBI may not be a party over here. No, CBI may not have appeared on 9th of November.
No.
May not have appeared on 9th of November.
CBI appeared. CBI appeared.
Okay, fine.
CBI had appeared and made.
May not have filed the counter at that
Yes.
stage, so somebody must have said CBI
Yes.
has recovered, because what is stated is CBI claims to have.
Some of my
Anyway,
colleagues.
read
here had-
further, read further, please.
She appeared as good.
Let ASC, Mr. Raju had appeared, I believe. Let, I think, out of 3.
Okay, fine, read further.
Yes, Mr. No, it's there in para 3.
Okay.
Mr. Raju Leonard, additional solicitor, has submitted that altogether 4 reports which are all.
Okay, read further.
Yes. Now, para
Read,
5.
Just go up a little, we'll read the sentences, sir.
Yes. Now, kindly see, in our opinion, para 8.
Yes.
May I read para 7 and 8.
Yes, please.
We have heard the submissions made by the Learned Senior Counsel and Learned Additional Solicitors and are appearing for their respective parties, and are of the view that the substantive hearing of all the proceedings which have generated this set of appeals petitions before this court ought to be conducted by the High Court only. We are apprised that all the petitions from these so-and-so except so-and-so are still pending before the High Court. We have briefly described the nature of orders being passed by the High Court at the interim stage of hearing this order. In our opinion, piecemeal proceedings are not warranted in relation to the disputes of this dimension, and termination of service of candidates at the interim stage before the final dismissal of the petition also ought to have been avoided. Having regard to the nature of the controversy involved in these proceedings, it was necessary for the High Court to examine the admissibility of the OMR sheet images recovered by the CBI before placing full-scale reliance on them in directing termination of services of the concerned employees. This is not even done by the High Court. I'll show. We are not suggesting that in cases of gross irregularities directing upon a certain individual, termination at the interim stage is altogether impermissible. If some grave error in the appointment can be demonstrated, services can be terminated in the interlocutory stage. But in the present set of proceeding at this stage, unsuccessful candidates have not been able to make out such outstanding case at the interim stage. Investigation by the CBI is yet to be completed. Argument of corrupting the original OMR sheet is yet to be supported by cogent evidence. In none of the orders impugned before us, there is no clear-cut finding that there was distortion in OMR sheet evaluation.
But then it was the state where West Bengal and SCC also party. So they didn't say that OMR sheets are not available. Why did they not say that?
No, but the
One
mirror
This
image.
goes, 1 minute, please. At this stage, the argument proceeds on the basis that it has to be collated with the original OMR sheets. the physical OMR sheets. They were as if they were.
The mirror image, which is said to be retained in the data.
There's
in the
no
computer.
mirror image also.
This was the arguments after here, but this was the finding after hearing.
Just
the
read that
PK.
careful, just read that sentence carefully once again.
Today, at this stage, we are not sitting in judgment over these.
No, we are not, we are just referring to what was argued by the parties at that time.
Yes, and minute, what was the conclusion? This is minute, the argument of corrupting the original is said to be supported by cogent evidence.
Yes.
It's a finding.
Yes.
It's a finding. In none of the orders impugned before us, there is a clear-cut finding that there was no clear-cut finding that was distortion OMR sheet evaluation. Question of exercise of power under the aforesaid three rules also arise out of discovery of electronically stored OMR sheets. Serious allegations have been made of manipulation of records in exchange of money, but these allegations would have to be established through evidence. It is also our opinion, considering the importance of the points of law involved in these cases, number of persons who are likely to be affected by the outcome of these proceedings, and also having regard to the fact that majority of the writ petitions giving rights to these proceedings have strong attributes of public interest litigation, this court would consider it preferable to have these proceedings before heard by a division bench of the High Court. Then, Millard, they go into Mr. Patwalia's argument, and then kindly now come to the directions issued in para 12. Yes, paragraph. Yeah. Millard, kindly come, Millard, to the top of page 741. Division bench may consider issuing a similar order only after authenticity of these images are established before it by applying the prevailing rules of evidence. We have consciously avoided in this order any finding on merits of the individual cases, lest such observation or findings influence the bench to be constituted for hearing of the subject controversy. We are, however, passing the order of protecting the employment of those already in service, as we are of the view that some element of status quo should be maintained. We accordingly direct the CBI to complete the investigation within 2 months and submit its reports before the High Court. CBI should also be at liberty to take such steps as may be lawful in pursuant of the investigation. We also direct that protection of to the appointment which is being accorded today shall continue for a period of 6 months to enable division bench to finally adjudicate on the subject dispute. Proceedings in which the petitioner appellants have approached this court directly without being pleaded shall also have the right of audience before the High Court, but for this purpose, appropriate application shall have to be filed. As then leaves it to the division bench to decide the mode of
Okay, fine, we have understood.
yeah. These are the broadly the findings. Now, Millard, when the matter goes back, kindly now come to page 900. Page 900.
Yes,
Millard, this is the proceedings of the court dated 19 January 2024.
yes,
Yeah. Requesting for inspection, etc. And Millard, please see Millard at page 902.
yes,
I'm not reading the earlier part. We have considered the last 2 paragraphs. We have considered the rival contentions of the parties as also the order of Supreme Court. Honorable Supreme Court requires us to consider the issue as to whether the authenticity of images were established by applying the prevailing rules of evidence or not. Images are in electronic format. They are said to be contained in the 3 electronic devices, again claimed to be seized by the CBI from an employee of NISA, an entity which was who was entrusted with the scanning and evaluation of the OMR sheet, wholly without prejudice to the rights and contentions of the party. We deem it appropriate to direct the CBI to produce electronic devices seized from the employee of NISA on January 24, 2024. It is submitted by so-and-so, a learned Deputy Solicitor General, that seized electronic devices were sent to Central Forensic Science Laboratory. CBI retained a copy of the contents of such devices. CBI shall preferably produce electronic devices seized from their... It was never produced. They were said to be lying with CFSL, never produced before the High Court. CBI shall also produce the original certificate issued by the ex-employee of NISA, annexed to the affidavit of CBA on the next day. School, on that day, when this matter came up, a photocopy had been filed, therefore they were asked to produce the original certificate issued by the ex-employee. School Service Commission will also certify and produce the data available to them with regard to the 4 categories of cases before us on the next day. Again, same direction with regard to inspection of such produced material. Materials produced will apply. These directions will cover all categories of cases that are being heard by us. Issuer's right of cross-examination will be considered even when raised by any individual part. Then, Millard, we go to the next proceeding, which are at page 954, that is the 24th January, 5 days thereafter. 954.
Yes.
Yes. Exception to the affidavit of Central Bureau of Investigation already filed in court be taken on record. At the commencement of hearing, Mr. Vikas Ranjan Bhattacharya, Learned Senior Counsel appearing for.
Okay, some logistics. We like your side to conclude by 3 o'clock.
I'll take 10.
So,
Lord, I-
whoever makes,
Lord, I'll pray for 10 minutes. Lord, I'm for untainted candidates whose name has not been found anywhere in any of the
whatever it is, please do not repeat. We will curtail
No
the
repetition.
of this on this side till 3 o'clock.
Very well.
Please distribute the time how you want to do it.
All of us have also filed submissions, so we'll advert to that and finish it fast.
Yes.
10 minutes. 10.
If you have anything else to say other than what has been said, you can certainly take time,
Yes.
but do not repeat. That's
Yes,
it.
no. Yes.
Because now, please, we have made it very
And,
clear, whoever, because we like to hear them for about an hour so that we can conclude if possible today. Otherwise, we'll continue tomorrow.
Very well.
Lord, in,
Mr. Bhushan,
yes,
let me say at the outset, we have not been entertaining any contempt petitions. In fact, all of them are pending.
Volume Mohit.
Any notice in
Out.
any of
Volume.
we have not been entertaining any of it.
pardon, Lord?
We have not been entertaining any contempt petition or applications. What we have been directing is,
Yes.
wherever there is an issue, please approach the authorities concerned. Because otherwise we'll be flooded.
Actually, what has been happening, I'll just tell
We'll
you.
be flooded with matters over
We have
here.
approached.
Then please approach the High Court after that.
Pardon, Lord?
Please approach the High Court. if
But it
required.
is your lordship's order.
I know
No,
that.
certain out down.
Just see the terms of the order.
We have seen that, Mr. Bhushan. There are so many matters of this nature which are coming before us. It will be impossible
I
for us to deal with
understand,
them.
I understand, but if your lordship directs,
We
Your
will
Lordship-
permit you to move the.
this will, actually, my lord, this will go on unless this court cracks the whip even in one case.
No, Mr.
Once-
Bhushan, we will not be able to do it. There are matters coming from both the sides. There are issues coming from both the sides. We have not done it even in earlier matters, and I will not make an
But
exception.
Lord, this is so serious, just,
Mr. Bhushan, other matters were equally serious. We managed to control it by passing those orders. Several cases we've been able to, and in fact, there is such
but
anything.
the problem is, my lord, this is going on repeatedly for the last.
Mr. Bhushan, we are aware of it. We are keeping it track of it. Many cases we have been able to solve that. Mr. Nataraj, you are appearing in this matter?
Please, yes, I'm here.
Mr.
Yes,
Nataraj,
I'm here.
Just please tell the
Yeah.
authorities to keep a watch. Their orders.
Very well.
Already.
Yes.
That they must keep a track
Yes.
of what is happening, video recording if it is required, that has to be done. The
Yes.
nodal officers must keep a track of what is happening.
Please, we'll do that. We'll do that. We'll
The
take.
mere fact that we are not entertaining the contempt doesn't mean that any,
That's right.
the violations will take place of our orders.
Yes. Yes.
Because really speaking, this is an order saying that no offense will be committed. There are sometimes there are offenses committed. We can't.
Lord,
Right.
the peremptory nature of this court's order was.
Mr. Bhushan, we are aware of that. Don't keep on repeating. We can't do that. We have not, it's not the first case. There are a number of cases where we have not issued.
But if it continues to go on.
Mr. Bhushan, we have a problem. We are not saying there is no problem. That's why we kept the matter pending. But then we have to also accept that all matters cannot come to the apex court.
But my lord,
If I entertain one, I'll have to entertain all.
no,
Sorry, Mr. Bhushan.
it will stop.
No, Mr.
Once-
Bhushan,
once-
Mr. Bhushan. that's
Once
not
the
possible.
court
We are,
cracks
we are
the whip
trying to stop it
in
in our
one
own.
case, it will stop.
No, Mr. Bhushan, right on.
Somebody or the
Mr.
other
Bhushan,
should
that's
be
what-
held accountable.
Mr. Bhushan, that's right on. We are not inclined to entertain the present contempt petition and leave it open to the petitioner to to the applicants to take recourse, applicant petitioners to take recourse to appropriate remedies as are available to the law. At the same time, we deem it appropriate to reiterate our earlier orders which require the district authorities, including the nodal officers, to take all precautionary as well as other measures to ensure that there is compliance of law and the orders passed by this court.
Please, we'll do.
In this
I'm
case,
ready.
there was an additional problem. There was that the bail condition of this gentleman
You
was,
can ask for, in case he makes that statement, you can ask for cancellation of bail. Will you come directly to the Supreme Court for that?
the police has to actually, my lord, cancel
No,
his
please,
bail,
no,
has to
please.
move for cancellation of his bail.
You can ask, the party can also move.
My lord, the High Court has proceeded on a completely factually.
Why?
sound
Why?
premise.
In fact, let me put it, you have not filed the relevant paper. Page R, which is
No,
the.
actually, my lord, we filed it. It was yesterday under objection. My lord, we have already filed it.
That's
Your
not,
Lordship,
let
kindly-
it come up on.
Before the High Court also, it was there, my lord. Just kindly,
You don't put the page number, you don't give anything.
Lord, I'm sorry about that. Your Lordship may just kindly see
Which is the page, which is the next R?
our reply to the show cause, my lord, to the clarification.
Not clarification, which
Yes.
page?
That is page 21 in this edition document. 13th June, we sent the reply, my lord. And we have got it acknowledged. We sent it by hand as well as by email.
As per the judgment also, you did not give the reply.
My lord, that's what I'm saying. It's a factually wrong premise.
But you over here don't also file it. Where is the acknowledgement over here?
My lord, your lordship may kindly see.
Where is the acknowledgement on
These are
page
the
2021?
The email and with the acknowledgement, my lord. In fact, they did not file a parawise reply to our petition.
Maybe, but in
And we annex it.
the High Court also says the reply has not been filed.
No, kindly see.
Just 1 minute, let's
annexure-
read it. Let's read this.
Exhibit N.
Just 1 minute, please.
Lord, page 332.
Just 1 minute,
Yes,
please.
yes, Lord. Thank you.
Number 3 is, what is this? You provide forget about 1 and 2. The third one is not complied. You say, please provide me a format of affidavit. What is this?
My lord,
Affidavit can be provided, can be written by anybody.
my lord, in these tenders, they normally have lot of
Oh, no, not
annexures
required.
and
Oh,
formats.
even one is enough to throw you out. You say, please provide me a content of affidavit. You can draft an affidavit yourself. Others have done it also. Sorry,
Just kindly see, my lord.
no, Mr.
Lord,
Even
couple
one,
of-
you have first not filed it, the third is certainly not compliant. Sorry.
Your lordship may see page 140, my lord. They say that it has to be in a format. Just
Format,
kindly see, 159.
you could have, others have done it, no? Others could have done it, you could have given that.
They should have responded, my lord.
No, no.
They should have
Not
responded.
required, not required.
And kindly see, my lord, under the procedure, the requirement was that they will upload the rejection of technical bid. After 1 week, they will open at least minimum 1 week. They open within 7 minutes of that. The whole purpose of that was,
That will not.
my lord, kindly see, the whole purpose was that if there is any clarification required, we are able to do.
No, they issued, the very fact that they must have opened the technical bid, therefore they came to know that your papers were lacking, therefore they asked you for those details.
My lord, after that, after the technical bid rejection, they are supposed to give reasons. This is the rule.
No, that-
This is the tender
that's
condition.
been rightly
They will
dealt
give
with.
the grounds. They
No.
don't communicate the grounds. And within minutes of that, my lord, they
That
open
has
the,
been dealt with rightly, it's an administrative order when you reject.
and June my lord, kindly see, June they had sought
The
the
contract
clarification.
has been entered into, is working now.
My lord, in fact, he is not even eligible on the face of it. The minimum requirement was 7 years. His earliest contract, which he has furnished, is
That's been dealt with,
2021.
that's been dealt with in the review.
My lord, that,
We're not
with
inclined
respect,
to-
that has not been dealt.
Sorry.
7 years, he's not having that clarification.
We are not inclined to interfere with the influence judgment and especially petitions discussed. Next case.
Wait, please. My lords, in the morning, were saying that perhaps the bench was not aware when it was ordered in November that the original sheets have been destroyed. Please see page 577. On 6th December 2022, the statement had been made by the commission that the original OMR sheets have been destroyed. Therefore, my lord, it was known even by 2022 and 2023 when the order was passed, my lord, the bench was aware of it. Well, I just wanted to, now if I may continue, my lord, page 954 I was on.
Yes.
Please see 954 at the commencement of hearing so and so. Now, he draws attention of the court, fifth line, to the contents of such affidavit and submits that in response to a right to information application made on February 24. School Service Commission by a writing dated January 18, 2024 stated that School Service Commission possesses the OMR sheet he draws attention of the court to the photocopy of the OMR sheet as made over to Anindita Bera by the School Service Commission. He submits that the School Service Commission is in possession of the OMR sheet and therefore School Service Commission be directed to produce the same. I don't know, the completely conflicting. Now kindly come to Millard, page for 950, next page.
This will go against you, in fact.
Millard, no, if it is there, the best.
So completely, when they make the statement that the State Service Commission is in possession.
Millard, I am now being damned without being heard.
No,
without
you're not,
production
you're
of
being
the
heard
record.
over here.
Yeah.
You're being heard over here.
Millard, I'm grateful to my lords for hearing me. Millard, page 955. My last two lines. He submits that Honorable Supreme Court restraint publication of OMR in the public forum, submits a record to be considered by the court prior to deciding the admissibility of evidence. Affidavit filed today should not be taken on record. So-called OMR sheet annexed should not be taken as side to side. Now, skipping one paragraph, Learned Deputy Solicitor General submits that seized electronic devices were sent for forensic examination to Hyderabad.
Are you reading?
I'm sorry.
For 955,
Next. Learned Deputy, page 956.
956.
Yes, ma'am. Third paragraph. Learned Deputy Solicitor General submits that seized electronic devices were sent for forensic science examination to Hyderabad. And the Central Forensic Science Laboratory at Hyderabad, who by writing declined to examine the same since the materials containing the electronic devices were voluminous in nature. Hyderabad at CFSL was including such materials, he submits are expected to reach. Therefore, no examination. See, then Millard, kindly come to page 1013. This is the proceedings of 5th February. When the original of 65D certificate is produced to file, etc. But I'll skip that part of it. Please go over to page 1015. Learned advocate appearing for the School Service Commission files a sealed envelope containing hard copies of candidates in the panel and waiting list showing OMR marks. 4 compact lists with regard to 4 categories of candidates showing OMR server marks of all candidates. These be kept with the records. Admissibility of these evidence will be decided at the hearing along with other issues. In view of the order of the Honorable Supreme Court, number of matters pending and the issues required to be decided as specified by Honorable Supreme Court, we propose to hear the matters on the basis of affidavit evidence. In such circumstances, it would be appropriate to permit the opposing parties one opportunity to use affidavit dealing with the documents are to be relied on by the petition and other parties filed today. We actually file affidavit. I'm not, in view of the shortage of time, I'm not taking my lords through all the affidavits, but kindly note the pages, Miller. 2760, 2808, 2838, 2853, where we have filed affidavits, raising objections, and Miller setting out in detail why these are not authentic, cannot be relied upon.
What cannot be relied upon?
Yes. And
What cannot be relied upon?
no, the records produced and the status of allegations in the status report of CBI are not substantiated.
Please. That even the SEC is accepting. Please, we will not argue on that. Don't go on that.
I'm saying that the data, basic data on the basis of
No, they have even accepting. That's not going to all that.
somebody should consider them.
God,
Nobody has considered. High Court has not even dealt with our objection.
you're going to the other extreme.
I am the person's allegedly tainted person.
You'll probably-
I am saying there is no material to show that I am
You'll have to
tainted.
probably deal with the prosecution then.
The problem is that my lords keep repeating every day that everybody should be given an opportunity. Here I am before my lord saying that there is no material which can be relied upon to say that I am tainted. And
What are you
nobody
arguing that in all the cases of those 20 or 1,000 or 20 lakh students, application should have been number 1. Number 2, that 25,000 should have been issued show cause notice. Number 3, at least those 15 or 30,000 or 40,000, 4 or 5,000 who had whose marks were found to be manipulated. How can that be possible?
Somebody
You have
has
be
to
realistic about it.
demonstrate, either the petitioner or
They
CBI,
have
somebody.
demonstrated, please. Look, we have to believe SSC themselves say, yes, they are wrongdoings. They are not hiding that. The board also says there is wrongdoing. The ones who are appointed.
The authorities who are supposed to have colluded.
The CBI also says there is wrongdoing.
Well, CBI is the
Somewhere you'll have
person,
to-
well,
We
the
are going by-
authorities,
We are going by preponderance.
well, the authorities who are supposed to have colluded in this, they say they are okay. See, what CBI says is gospel truth.
In fact, they had to concede because they were cornered. That's all. That's the
Well,
explanation.
they want to extricate themselves from this. Well, there is nothing to demonstrate that we are in any manner tainted. That's that somebody has to take on the onus. Nobody has produced any document. We have written the exam, we have passed, we have got good marks, we have been selected, we have been appointed, we are functioning. Now, we are being thrown out without even anything being proved against us. Now, kindly see, page 1016. So far as the prayer of Deputy Solicitor General with regard to original electronic devices are concerned, it would be appropriate to permit the CBI to produce such originals with CFSL Calcutta. When they were to be produced, then who require inspection of OMR sheets may send such requisition. Now, kindly come to the judgment. I have given the affidavit pages. Our written submissions elaborately deal with each one of the objections. They are at page 2868 onward. 2868 onward. None of this is considered. Kindly now come to page 210. 210.
Yes,
Let para 240 the chart.
yes.
Let this doesn't match. CBI by SSC has submitted a statistical report. CBI gives another report. Not these do not tally. This contains one number. There is another number. Kindly see page. Compare this with page 248. Para 305. The numbers given here or do not tally with, there is no manipulation of 950 numbers. Here it says 993. There is nothing matching in regard to any one of this. Now please see page 273. Para 273. SSC, para 273 at page 229 or 227. I have 227.
Para 273 at page number?
I think either 227 or 229. 227, yes. SSC had at no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegalities of recommendations, but had limited it itself. Therefore, SSC has not checked. Now, kindly come to page 288, or para 288. Now, kindly start with para 286. Order of remand dated November 9, 2023, passed by Supreme Court in relation to present matter, has required us to pronounce on the admissibility of data contained in the 3 hard disks. Issue of admissibility on the data contained in the 3 hard disks have been raised by the beneficiary of the fraud. You have already come to a conclusion, I am the beneficiary of the fraud, without even deciding on the admissibility. Kindly look at this, therefore I am condemned. And then thereafter, I put on a peg. And none of the Article 12 authorities had ever disputed the genuineness, veracity, authenticity, and legality of data contained in the. If they don't, I have disputed, I have filed affidavits, I have produced material.
How can you dispute that? That's just checking of mark sheet, all that you could have.
I am saying,
How can
this
you
is not
dispute that?
my, what you are showing as OMR sheet.
Your OMR sheet is something different from the marks you have obtained.
Therefore,
You are not privy to that.
there has to be some method of proving that I have not secured the marks which I claim I have got.
They
and
have
based on-
examined that. They have examined that.
Yeah.
That
Let-
they have examined.
Attending by SSC and
You are in one of those categories where the marks were different from the OMR sheet.
yeah, no, I am in the second set of categories where Mr. Jaideep Gupta has in the affidavit, not the one who jumped, not the one who has been brought, taken through the back door, but whose marks don't match with the OMR. Yeah, that's right. 288.
You are the one who marks don't match, no? The one-
How am I? Can I be asked to prove?
1 minute, please.
Can the onus be put on me?
No, there's no onus on you. Because there's no onus on you. Because you are never aware of the marks also, so you're never aware of them.
How do I prove that?
We were aware, marks were published. I'm also in the same category.
There's no onus on you. Because you are never aware.
Let's take 5 minutes after. But
How do I?
Marks were published, but you're not the marker.
I'll respond after you.
You're not the checker.
Just respond after.
Yeah.
You're not the one who checked it.
I'm also in the same category, but I'm going to.
Good.
Completely different suggestion. I'll deal with it after.
Para 288. SSC had accepted such data, acted upon it, found manipulation, illegalities of the OMR sheet, proceeded on replace such data. Therefore, they say, we will act on.
You are never aware.
In my respectful submission, we dispute it, we deal with it in our affidavit. That's the only opportunity given to us, nothing else. We have put in our written submission, none of those.
I'll respond after introduction.
And we were kindly now
You're not the one who checked it.
I'm also in the
come
same
to
category, but I'm
page
Good.
para 294.
I'll deal
Yes.
with it after.
In our view, the fact that the three hard disk contain data related to four categories of selection process conducted by SSC had accepted such data, acted upon it, found manipulation, illegalities of the OMR sheet, proceeded on replace such data. Therefore, they say, that's proved by whom? By SSC and state making admissions with regard to in the application filed in the writ petition and by the court. And
You've understood your argument that you don't believe that the SEC is accepted. That there is wrongdoing is correct.
will act on.
So the action says we
In
are
my
checkers, but
respectful
made
submission,
mistakes. have
we
done some public.
dispute it, we
Mistake
deal
was
with it in our
accepted.
affidavit. That's the only opportunity given to us,
Because-
nothing else.
because
We have put in our written
you-
submission, none of those.
I'll respond after introduction.
And we were kindly now.
You gave the exam, but you did not.
No, we gave the exam, we have been selected. We got the mark.
The only thing is because you gave the exam, so therefore don't.
In
believe the
our
SEC
view,
who-
the fact
who
that the
then-
three
No, we
hard
have
disk
done
contain
that.
data
Not
related
only
to
that,
para
we-
288
we-
selection process conducted by SSC had accepted such data, acted upon it, found manipulation, illegalities of the OMR sheet, proceeded on replace such data. Therefore, they say, that's proved by whom? By SSC and state making admissions with regard.
There is a mismatch. Now, please have page 305. I just want to read that CBI affidavit. That can this OMR sheet be at all relied upon? Because everybody today says there is a mismatch. But the basis of everybody saying is because what the board says, board doesn't have OMR sheet. Board has destroyed those sheets. Board probably has some score.
That the SEC is accepted.
or doesn't have some score is not very clear, assuming that the board has a total score. And an OMR sheet is recovered, and that score is not tallying with the OMR sheet record, and therefore it is said that there is a mismatch. Now please see just 4 paras of that. Now, according to this affidavit, at this stage,
You gave the exam, but you did not.
No. We gave the exam.
is merely part of the investigation, cannot be relied upon. The whole, your lordships just observed when my lordship was arguing, that says that there is a mismatch. But the point is, every authority is saying on the basis of the same recovery from that gentleman. And that gentleman in his 65B certificate says, to the best of my knowledge, this is okay. 25,000 people cannot be ousted on that basis. Lord. The facts are, the assistant teacher process starts in 2016. In January 2019, we are appointed, we are working. Up to August 22, there is no challenge. The first writ petition is filed in
please
August
have page
22 after
305.
almost 3
I just
years.
want to read that.
In that writ petition, we are not made parties. At some
CBI
stage of
affidavit.
proceeding of
That
that writ
can
petition,
this OMR
the court
sheet
says,
be at all
let there be a
relied upon?
CBI investigation.
Because
We are
everybody
still not
today
parties.
the basis of everybody's saying
Ultimately, my lord,
is because what
one
the board
finding,
says,
the
board doesn't have
passes an
OMR,
order
board has destroyed
on
those sheets. Board
2nd
probably has some
April
score.
2023, the court passes the first order on 2nd April 2023, directing the board, 2nd February 2023,
assuming that the board has a
directing the
total
board to exercise
and
power
OMR
under Rule
sheet is
17.
recovered, and that
Rule
score
17 is a
not
rule
tallying
where if the board makes
and
a
therefore it is
recommendation,
said that there is a
then that
mismatch.
recommendation the board is
just
entitled
4
to
paras of
withdraw.
that.
Recommendation was made in
According to
April. 4 years
this
before this order was
at this
passed.
stage,
The court tells the board, the commission when it is of the opinion recommendations were made mistakenly or erroneously, it is obliged to exercise the power under Rule 17. The court says you please look into it and exercise power. The board then comes and files an affidavit. Yes, we will exercise the power. The court in the second order
cannot be relied
you don't
upon.
need to hear
The whole, your lord,
The board says yes, I don't need to hear.
When
we
that
get to know
says
this,
that there is a
we
mismatch.
file an
But the
application.
point is, every authority is saying on the
The
basis
single
of
bench
the
rejects
recovery
our application
from
for
that
it.
gentleman.
We
And
go
that
to the division
gentleman in
bench.
his 65B
The division bench
certificate
says there are
says,
too many of
to the best of
Some
my
of you
knowledge,
can
this
be
is
impeached
okay.
in representative capacity. But so far as 17
17
that action is concerned, we are not staying.
The facts
First
are,
March
the
2023
assistant
is
teacher
the order of the Supreme On 1st March 23, the board withdraws the recommendation.
we are appointed, we are
And on 1st March 23, over 5 years after we are appointed, we are
There is a
first
writ petition is filed in.
Please
August
this is,
305.
I
just
it is in
want
my
to
list
read
of
that.
dates,
In
I
that
will
writ
give the
petition,
page
we are
numbers
not made
to your
parties.
lordships in a
At
short
some
summation
stage of
affidavit.
proceeding of that.
So
can
this is what has
the
happened.
board says, be at let there
Please
lie
come
the
to
CBI
this court
investigation.
by way of
Everybody till
celebration,
now,
by way of
use
affidavit
regular
court order.
the
This
basis,
court
the
stays the
basis of
operation of
everybody's
our
saying
ultimately, my lord,
is
then
because
remands the
what
matter
one
back
point
to
says,
court.
the
And
court
that
doesn't have
order of
an
remand
order,
has
has
been read,
destroyed
my lord.
those sheets.
But I want
Second,
to read
April
2 parts
2023,
of that remand order, my lord. In
the
my
court
paper
passes
book,
the first
that
order
is at page.
on 2nd April 2023, directing the board,
Section 629, I am
directing the board
my
to
lord.
exercise, and that rule 17 is a
Compilation
where if the
7.
board makes a recommendation,
Compilation
then
page
that
7.
please see
Please
is
have
just
para.
a paragraph.
Please have para.
The commission when it is of the opinion recommendations were
The
made.
remand order is not compliant.
It is obliged to exercise the power under Rule 7.
So,
The court says
what
you
is
please look into it and
confronting the
exercise
court
power.
when the remand order
The
is
board
laid
then comes
is
and files
a
an
person
affidavit.
who is
Yes,
appointed in January
the board in the
2019
second order
is
cannot be
thrown out
relied
by
upon.
the
The whole,
board
your lord,
just
the board
in
just
a day. When we
that
and
says
what
that there is a mistake.
para
Every authority is saying on the single bench rejects our application from that gentleman.
Two things
And
the
that
board
gentleman in his
neither of the two
65
have
division
done.
bench says, to the best of
Some
my
of you
knowledge,
can be
this is
impeached in
okay.
representative capacity.
But
In our application, these proceedings are not warranted. Relating to systems of this dimension and termination of services.
On 1st March
All
23,
right, and just one line. It was necessary for the High Court first to examine the admissibility of the OMR feature.
Yeah,
This is
there is a
recovered by the
petition
CBI.
is filed. Please have this 305. I just want to read that in that petition we are not made
Your
parties.
lordships, I
That
can't
CBI affidavit proceeding of that regard. This is what has happened. See, at that there is CBI, this
CBI.
the basis of everybody's ultimately is demands the matter time says the court doesn't have the court has destroyed.
But I want
Second,
to list
April
two parts
2020
of that remand order to address that.
In my paper passes the first
That
order.
is at page.
On 2nd April 2020.
Full-scale reliance. My will show your lordships where the High Court examines this as.
Yeah, please, one thing. The.
3. Directing the board
Section 629. I just want to read
One
that.
minute, please. OMR sheets have various details, which is CBI. Do you think those details are not matching? They'll match those, they would have matched it. They would have matched it with SEC will be aware of the OMR sheets which were circulated at that time given to the student. We were worried on that score.
May I respond?
OMR sheets have been changed or not.
May I respond?
and that
Why-
board 7
He himself getting into a problem. What
SSC,
is,
yeah, he's an accused now. SSC,
so will he get?
SSC in its proceedings have recorded, all our record is destroyed.
You want to believe us that factual?
No, my lord, just allow me to just proceed. Now, I'm conscious of what has fallen from your lordship. Unless I can read that, I'm going to so, my lord, I'm just going to come to that statement. But just one more line. So first thing which remand order said, first please examine whether it is at all admissible. Because, my lord, right from the Taj trapezium and earlier judgments your lordships have said, these status reports are investigation. They are not gospel truth. Unless they are tested in a trial, you cannot base findings on them. That's what your lordships have said. So this is only an investigation report. Now, second, which the court said, para 10, in the course of hearing. What is challenge when the remand order is made, the High Court saying you cannot rely on it? Those writs are segregated and they are still pending in the High Court. My writ, which I had challenged 65B, High Court says.
To the best of my knowledge, this is
What I'm trying to point out is, cannot be found in somebody's residence. And that man is not even working with NISA. And there is no way he could have had this record. And after getting the record, filing it in the High Court, our termination. Now he is not and tomorrow he says that he resigns. From his statement and says, this is not genuine, I have made it myself, or there is manipulation. The damage to us is done already because the trial has yet to start. So therefore, just see, my lord, how just bear with me for these 3-4 paras because it's a whole make or break so far as we are concerned. Just kindly, during investigation, I'm reading the affidavit is on the record. In the affidavit, 5 places the CBI says investigation is on. Investigation is on. This is part of investigation. So many places it is said. Now, during investigation, it was West Bengal Central School Service Commission had awarded work order to NISA for scanning and record. This is para 3. Para 4. Investigation has referred that Puneet Kumar was the director and Niladri Das was the vice president. It has been established during investigation that Niladri Das used to do it. We can leave that. Come to para 5.
Will show your lordship.
Investigation
Where
has
the High Court
established
examines this
that
as-
scanning of OMR sheets was undertaken by NISA at the West Bengal Selection Board office under direct supervision of Niladri Das in the presence of officials. It has further been established NISA had further given the work for scanning to Messrs. Data Scan who remained present. After completion of scanning, the processed data in the form of scanned images, scanned data were handed over by Data Scan Tech to NISA, who took the same to their office located in Noida, leaving the hard copies of OMR sheets in the office of the board. Board handed over their answer keys in respect of all subjects for evaluation.
We were worried on that score.
May I-
Things have been changed or not.
Evaluation of OMR responses. So far, nothing has happened. That OMR
What
sheet,
is,
yeah, he's an accused now. SSC,
so will he get?
SSC in its
His photo
proceedings
is
scanned, have recorded by this data
all our-
scan tech. It is given to NISA. The key is also given to NISA. Now, my lord, para 6. While scanning the sheets by data scan tech on behalf of NISA, two DAT files were recorded.
No,
My lord, 7 and 8. Also, your
just
lordship
allow
may
me to,
leave, my lord.
to just proceed.
Then 9.
Now, I'm conscious of
During
what has fallen from your
investigation,
lordship.
para 9, at page 10, unless I during investigation, the server database of the commission was seized by the CBI. All data pertaining
But
to
just one
selection
more
of
line.
so and so.
First thing which
That
the
during
remand
the
order
investigation
said,
of the
first,
case,
please examine
3
whether
hard
it is at
disks
all
were
admissible.
recovered on
Because,
15,
my lord, right
16
from the
September
Taj PCM and earlier
2022.
judgments, your lord, status
Now,
reports are
the
investigation.
selection process
They
is
are
in
not
16,
gospel
17.
truth. Unless
You are
they
recovering in
unless they are
2022.
tested in a
In the
trial,
meantime, what has
you
happened?
cannot base
Data
findings on
Scan
that.
Tech has
That's what your
bifurcated.
lordships have said.
Two
So
partners
this
have
is only an
separated.
investigation
This
report.
Pankaj
Now,
went with
second
the
which
second
the court
partner.
said.
He was no longer
Para
with
10.
NISA.
In
Then
the
the
course
second
of your-
partner's company also went to partner. Then this Pankaj joined a third company. And now he's trying to 65 certificate as an employee of a third company.
What is
For
required
challenge
challenge
or whatever.
the remand
From
order
these-
is-
and
those
this
writs
is the
are
gospel
segregated.
truth on which
And
everybody,
they're
the
still
board is
pending
coming and saying,
in the
yes,
High
yes, there is a
Court.
mismatch.
My writ which I had challenged 65.
Lord, it is
High
two
Court
species.
says.
Okay,
Contempt
that is two
is-
I'm not going to argue or say anything about the facts. Facts are before.
What I'm
Lordships,
trying to point
you've heard
out
all the
is-
facts.
I'm trying to
The
point
point
out.
I want,
Cannot
the point I want to make is very simple. Doubt, your lordship has seen it. I'm not going into the evidence.
And that man is not even working with NISA. And there is no
Admittedly, there is some material. Admittedly, that material points to certain amount of manipulations. I'm just going on it as the worst, my lords, is what can be taken. The two questions which would then arise to your lordships is, what is the consequences? One is submission of the SCC. I'm going on them. As your lordships are putting it to others who are arguing, what do you have to say when the SCC itself has said so? Please see the submission, just see that.
statement and says, this is not genuine, I have made it myself, there is manipulation.
Volume 6.
The
Kindly,
damage
my
to
lords,
us is
turn
done
to
already
page 16.
because the trial has yet to start.
It starts at page
So therefore
15.
just seem
Kindly
how
turn to
it-
page
just
16,
bear with
volume
me
6.
For these 3-4 paras, because
Yes.
it's a whole make or break so far. as we
Paragraph
are
6.
concerned.
It is stated
Just during investigation, affidavit is on the record. In the affidavit, 5 places the CBI says investigation is
that on a careful scrutiny. My lord, let me say straight away, I'm for these assistant teachers of 9 and 10. Not in that.
During investigation, what is the
That's why I'm trying to say.
had awarded work order to NISA for scanning and record. This has referred that
This is the SEC submission on the commissions. My lords, kindly see paragraph 6. It is stated that on a careful scrutiny, commission prima facie noticed that there are candidates who can be said to have appeared to have jumped their ranks.
was the director.
That is to say, people having lower rank
It has been
have been
established during
preferred over
investigation
persons having
that
higher
Niladri
rank.
Das used
It was
cable
also
drive.
prima
We can
facie
keep
seen
that.
that some candidates have been recommended for appointment without being in the panel or
Scanning
appointed
of
without
OMR
recommendation.
sheets
Number of
was
such
undertaken
candidates
by
are as follows. Assistant teachers rank jumps out of panel but appointed 185.
In the presence
My
of
lords,
officials,
I'm not
it has
there
further been
in that
established.
category at
NISA
all.
had further given the
Then, my
work
lords, I'm not on. Paragraph 7 goes on what CBI, because your lordship said there was a concurrence between SEC and CBI. This is what CBI says, even in the investigation, it has
Two
been
measures
found
data
that
scanned
some
who
appointments,
remain
even in the
present after completion of scanning, the processed data in the form of scanned images, scanned data were handed over by data scan tech.
investigation by CBI, it has been allegedly found that some appointments were alleged to be manipulated by allegedly manipulating OMR scores, which are
NISA,
part of that.
who
And
took
that
the
is
same
where
to
this
their office
808
located
comes
in-
in. Not 952, as it was pointed out, it is 808 on who were appointed. So the point I'm trying to make, my lords, is whatever it is, dissimilars should not be treated
Noida,
similarly. What has
leaving
happened
the
is on
hard
the strength
copies
of this,
of OMR sheets
the High Court has thrown out everyone, 13,000 people. Now, my own submission to your lordship, subject to what you feel, my lords, is that SEC has found that
The office of the
these
board-
category
board handed
of
over
people
their
who are
answer
not at all in the
in
panel but
respect
still
of all
appointed or
subjects
jumped
or
rank.
We were worried.
My lord, I can understand. But regarding others who are at that evidentiary stage, surely, my lords, we will have to be subject to whatever is decided finally, whatever this evidence
On that score.
brings out, whatever it finally brings out in whatever the inquiries are pursuant to this. But they cannot be treated, 6 and 7. 7 is based on what CBI has said, not what SEC said. 6 is what SEC has found after going through the CBI report. Now, 6 I can understand is one category, but you cannot mulct 7 in that category and say even 7 requires no inquiry whatsoever. That is all I want to submit to my lords is, number 1, let the baby not be thrown out with the bathwater. Because of this, let everything not be set aside. 2, amongst those who are found to have in some way possibly been favored here or there,
That OMR, yeah, he's an accused now. SSC in its proceeding is scanned, have recorded,
please
scanned.
deal with them. But my lords, it can't be dealt with that I'm peremptorily thrown out as item 6 would be peremptorily thrown out. This is a subject matter of some kind of inquiry. All I'm seeking is that regarding these people, let there be some kind of inquiry. We don't have a huge amount here. It's only those people, and I'm talking about the paragraph 7.
It is
That's
given
all
to
I'm
NISA.
seeking, my lords.
The
And
key is also given
do not
to NISA.
treat
Now,
dissimilars
my lord,
similarly
six.
is all
While
that I'm
scanning
seeking
the
of your
sheets by
lordship
data
finally
scan
here.
record,
Because we have so
two
many
DAT
different
files were
categories here. We have those, my lords, who are in the 13th.
Audit, no, Lord, 7 and 8, also your lordship may leave, my lord. Then 9. Now, I'm conscious during investigation.
1,000. Those who are in the else, That's it, my lords. And therefore, I'm only submitting, and my suggestion is only this to your lordships. Please, my lords, mold the relief accordingly based on who is in which category. But surely people whom yes.
But just one more line. So and so. First thing which that during the investigation of the case, please examine
CC has not found. I have to have an opportunity at least, if nothing else. I'm not saying for everything. I'm not pleading natural justice. I'm not pleading. But surely it can await some judging of that evidentiary content. That is all I'm saying, Manoj.
unless you are recovering in progress, they are tested in the meantime. What has happened? Cannot base data standard. That's what your lordships have said. Two parts. This is separate investigation. This Pankaj the second section para 10. Then the second part is
electronic or digital form. The opinion of the examiner of electronic evidence referred to section 79A of the Information Technology Act is a relevant fact. Now, these section 79A and section 45A, 79A of the Information Technology Act and section 45A of the Evidence Act were amended on the same day. And section 79A of the Evidence Act says the central government responded faster by providing and on electronic form evidence before any court or the other authority specify by notification in the official case. Any department, body or agency or a state government as an examiner of electronic evidence. Now, this has been done there by the central government. Different laboratory has been established. Now, there is no certificate first for the formation of opinion or the taking into it the relevant fact. Section 45A of the Evidence Act, it has not been complied. My second submission would be, my lord, your lordship
it doesn't give the mode of proof rate. It's a relevant fact.
Doubt, your lordship has seen it.
relevant
I'm not
fact?
going into the
and that man is not even working with the
also doesn't apply
and there is no
with petitions.
That's
Let's
correct,
not-
Ballard.
Let's not go around in a tangent.
But earlier the judgment, earlier the order which has been delivered
Admittedly,
by this court,
there is some
where the
material.
Evidence Act, has been-
Admittedly,
Ballard,
that material points to
Apply.
certain amount of
Kindly just-
manipulations.
There are
I'm just going on
provisions of
it at the
evidence
worst,
that
my lords,
can
is what can be
taken
taken.
into account, but it's not.
The two questions which would then
Ballard,
arise to your
65
lordships is, what is the consequence?
65B4.
Here the
He could have
CFSL
had this
report has
record.
been obtained.
and after
All that it says is
What do you have to say when the SEC itself has said so? Please see the submission, just see that.
Not,
No, it's
it
not
has
been
not
obtained.
obtained. It has not
There's
obtained.
no FSL.
CFSL report has not been obtained.
I think forensic examination of the has been done. The mega data has been there. Is there? You're wrong on that.
Millard, it has not been obtained, Millard, kindly.
It has been obtained. It was sent to the forensic examination in Calcutta. That report has.
Millard, it has not been recorded, declined. They have declined that they would not do it.
Okay.
There's
CFSL
not,
Hyderabad declined, not Kolkata.
pardon, Millard?
CFSL Hyderabad declined.
Yes,
Thereafter, it seems to have gone to Kolkata CFSL.
Millard, thereafter, not in any other laboratory, it has
The
not.
finding that the hard drives have not been contaminated.
Thereafter,
That was read
it has
out
not,
twice.
it has been not sent to any other laboratory.
statement
Okay,
and
fine.
says this is not genuine. I have made it myself. There is manipulation.
Six,
Kindly,
The
kindly, my
damage
lords,
is
turn
done
to
The only way to prove.
Millard, kindly see 65 2B4. 2B4 speaks about who will Millard give this certificate. Not everyone. Millard, kindly see this. I am coming to very relevant portion. I am not reading any 65 4B.
The trial has yet
The
to
one
start.
who
It starts at
downloads
page
gives us a
15.
just see
Kindly
The
turn
one
to
who
page
downloads-
16,
Bear with
volume
me.
6.
These three,
Yes,
four paras.
that's the law.
Yes, no, purporting to, kindly Millard, just excuse me, Millard.
We
Kindly.
have read
Millard,
65 so many times.
I understand, Millard. Kindly excuse me, Millard. Kindly excuse me. The commission
It's
is
a whole
sufficient
make or
to
break.
relate
So
paragraph
as
6.
purporting to be signed by
It
a
is
person
stated-
occupying a responsible official position
Correct.
in relation to the cost.
So from whose possession the CDs were recovered? The hard disks were recovered? From whose possession were hard disks recovered?
Data into operator, according to, but kindly read this CBI report, whether Pankaj Bansal's name is mentioned there.
Okay.
Millard, the two other persons, Millard, who are the persons in charge of the operation? They were there. Certificate has not been obtained from them. Certificate has been obtained from a person who has left the company and went to somewhere. This is there from the report itself, my lord.
Not even, in fact, 65B certificate is not required because it's the original document you are there.
In the affidavit, 5 places the CBI says investigation is.
Document, my lord, listen.
That on a careful scrutiny. My lord, let me say straight away, I'm for these assistant teachers of
Not
in that.
And you produce your laptop or your hard drive in the court, 65B certificate is not required.
That's a logic.
That's law.
My lord, very briefly, on the point of originality, my lord.
Had awarded
My
work
lords,
order
just
to
a very
NASA
brief
for
point on the
scanning
point
and
of
record.
originality.
This has referred
My lords, the OMRs
This is the
are
SEC submission
essentially
on basis
a
commissions.
sheet
My
with
lords,
dots
kindly
on
see
it.
paragraph 6.
Now,
It is stated
there is
that
an
on careful
additional
scrutiny,
document.
Commission prima facie noticed that there are candidates who can have,
Precisely, my
who
lords. Now,
can
my
be
lords,
said
then what
Thousand
happens?
pages that were given to us.
to have appeared to have jumped their ranks.
Was the director.
That is to say, people having lower rank
It has been
have been
established during
preferred over
investigation
persons having
that
higher
Niladri
rank.
Das was
It was
capable.
also
We can
prima
have
facie
one
established
paragraph.
that some candidates have been registered as appointed without being in the panel or appointed without recommendation. Number of such candidates are as follows. Panel of appointed 185.
In the presence
My
of
lords,
officials,
I'm not
it has
there
further been
in that
established.
category.
NISA has further given the.
Then, my lords, I'm not wrong. Paragraph
2826.
2806 also.
7
miscellaneous
goes on what?
Just
CBI,
scroll it,
because your
just
lordship
scroll
said
it.
there was a concurrence between SEC and CBI. This is
Scroll it. Scroll it.
My lords, so while they find that, the OMR, as my lords may imagine, we've all done multiple choice tests. That is the version of the email.
How the.
Now, what is the hash value that they have compared? It is not the hash value of every individual OMR. What they are saying,
They cannot.
that they, okay,
It will be impossible. But they would have done that because probably the scanned documents must be contained in one file itself.
what
And
SEC,
the hash
CBI
values would have
says,
come when they
even
checked
in
it
the
up.
investigation,
What they have
it
done
has
is
been
they
Messrs.
found
Data
that
scan
some
who
appointments
remain
Alright. We know when the CBI council tells us whether the hash
The-
values which
After
put in the
completion
date
of
on which
scanning,
they were
the
scanned,
processed
etc.
data in the
or
the
form of
from the
scanned images,
metadata, as my
scanned
lords
data
have
were
requested
handed
them.
over
But
by
my
data
lords,
scan
investigation by
when
CBI,
they
it has been
extracted the
allegedly
data
found that some
from the
appointments were
OMR
alleged
into a .dat file, there is, and I researched this extensively,
to be manipulated
across
by
the board,
allegedly
there is admissions that
manipulating
there are
OMR
generations.
scores which are part of that. And
For
that is where
example,
this
their office was
808
located
comes
in-
in, not
When
950.
in, not today as much, but in 2019 or 2018, we used to convert PDFs into Word files. There were errors. Now, my lords, what they've
So
done
as it was
is
pointed out, it is
that
808 on who are appointed.
they have
So
got
the
these
point I'm
response
trying to
strings
make, my lords, is
that
whatever
they
it is,
themselves created.
dissimilar should not be
And
treated
then you
similarly.
have
What
these
is
hash
leading is on
values with not one generational loss, but two, because there's the .dat file that then becomes the .dbf file, a third file. And then you compare the hash values, my lords. And so the thing is that,
You are supporting the complete obliteration of the result.
no, my lords,
strength
what
of
I'm
this.
saying is this.
The High
What
Court
I'm
has
saying, my
thrown out
lords, is that
everyone,
of course, all may
13,000
not be
people.
well in the state of Denmark. Of course.
You belong
That's just
to
a
which
fact.
Class C and D?
Now,
A
my
and
own
D?
submission
I'm
to your
in,
lordship, subject to what you
the
feel, my
9th and
lords,
10th.
is that
Ninth and tenth,
SEC
C and
has
D.
found
No,
that
No, not
these
C&D. C
categories,
is
Board handed
clerical.
over
people
their
who are not at all in the
I'm
panel
an
of
assistant
appointed
teacher
or
in
jumped
A&E.
rank.
Okay, ninth and tenth is the.
I'm 80 assistant teacher.
Tainted, not tainted.
Tainted, not
Tainted or not tainted?
My lords, I believe I am not
Not,
tainted.
not your belief. As per the order, do you fall in the tainted category?
My lords, as per the order, there are three types of tainted. And all three types of tainted are based on entirely different
We were
evidence.
worried.
Are you there?
So I am there
One
only
of those.
third category. So when we look at the
The
first,
third category, you got to jump in marks.
where the OMR is being challenged. So my lords, what we are saying, my lords, if I may just point to the differential in the value of the evidence between the people who are alleged to have jumped ranks.
My lord, I can understand. But regarding others who are at that evidentiary stage, surely, my lords, we will have to be subject to whatever is decided finally, whatever
But
this
my
happens.
lord, but my lord raised a question earlier, if I may.
There are certain things which are quite apparent.
No
Let's
doubt.
not argue.
But my lord, the things that are apparent, the ex facie wrongdoing with the
The
rank jumping.
sheets are there, the sheets are all there, the names are written, everything is there.
All I am saying, let it face process. Let
Brings
it go
out
through some
whatever it
process.
finally brings out.
Either
and
the
whatever-
criminal process, this Pankaj Bansal is going to fall under cross-examination. Or my lords, let it go through the 2018 rules.
Where petitions are decided.
Untainted category. I mean, the non.
First, let's deal with the tainted category and then.
I just want to make a
The
very
inquiries are
Then,
pursuant to
then
this.
your lordship
But
can.
they cannot be
that
treated,
partly
6 and
tainted or
7.
tainted, then
7 is
As
based
per your belief, as per the judgment that you are taking.
on what
First,
CBI
maybe
has
get
said,
back
not
when
what
the
SEC
CBI
said.
comes back with the metadata. Maybe get back to my lords on this.
For us to be said.
I'm grateful. I'm grateful.
We are in the untainted.
This is what SEC found after going through the CBI. Now, 6 I can understand is one category, but you cannot mulch 7 in that category and
Okay.
say even 7.
Tainted on this side, not.
I am untainted. I am untainted.
Okay, let's finish with the tainted first, then we go to.
Requires no inquiry whatsoever. That is all I want to
Okay,
submit to my
let's-
lords is, number one, let the baby not be thrown out with the bathwater. This, let everything not be set aside.
Separate categories.
Two,
One is
amongst
tainted,
those
one is
who are
not
found
tainted.
to have in some way possibly been
That means any report you have your names. Are different allegations. In group D, they say that I'm not in the panel. And there's no recommendation given by the commission where the board who's appointed me says commission in fact gave you the recommendation. Second category is rank jumping. Third, they say there was some tampering with your OMR, but commission says even if that 1 mark is taken care of, even then 31 candidates make it to the panel. I'm part of that 31 candidates. So there are 3 separate categories. My submission to your lordship today is as follows. What has the High Court done? The High Court has said, yes, there seems to be large-scale irregularities because of what has been said about the OMR sheets. Insofar as rank jumping, out of panel, there has been no discussion, nothing. Your lordship started off this hearing wondering if there's a possibility of segregation, and I'd like to address on that. Your lordship will see
But my lords, it
the
can't be
commission's
dealt
written
with that
submission.
I'm peremptorily
as-
thrown out.
At
as
page 17,
item
your
6
lordship,
would be
that is
peremptorily
in
thrown out.
volume
Subject matter,
page
some kind of
17
inquiry.
of the commission's
All I'm
written
seeking
submission.
is that regarding these people,
There is
let
a
there be some
table.
kind of inquiry.
But you are allegedly in the tainted category, how will this help you?
I'll tell you lordships why. As far as there are 2 of the 3 categories, which are
We don't have a
so-called rank
huge
jumping
amount
and
here.
so-called,
It's only
I did
those
not get a
people, and I'm
recommendation
talking
from
about
the
the paragraph
commission.
7.
According to me, I got
That's
a
all I'm seeking,
recommendation from
Manoj.
the
The
commission
keys
and
also
there has
cannot
been no
read
rank jumping.
this-
Now, these 2 issues are purely factual and they can be segregated from OMR. As far as my omnibus submission is, if your lordship will consider that even the CBI, the commission, whichever
Is
figure your
all that
lordship
I'm seeking of your lordship's finally. Because we have so many different categories here. We have those, my lords, who are in the
Your OMR
13th.
sheet is available, they have given that soft copy. You can identify your OMR sheet. You know the marks which are there, the corrected scores, you know the you know the correct answers. And you also know the marks which you have been given for being selected. Where is the big
So
deal?
this, no, the
Why are we
big
going
deal, the
around
big deal comes,
circles?
no, your lordship, the big deal is,
I'm
I'll tell you
saying
lordships.
that, look, this is all.
No, not at all, not at all. May I just make a submission? The marks are the same. In my category, my marks have not changed. The marks are same.
Thousand.
That-
But
Those
you
who
have been given more marks.
No. I have not been given. 2 of my 3 cases of no allegation of more
What has
marks.
happened?
Well, they have been given they've been
Appointment.
given appointment. Somebody above them has not been given.
It's the allegation. Is the allegation. Now may I submit?
Rank because of
But in
marks,
the end,
not because of
that's
marks.
it, my lords, and therefore I'm only submitting, and my suggestion is only this to your lordships. Please, my lords, mold the
So
relief
my first,
accordingly based on.
submission to your lordship is the lordship.
How set it out? The marks are known. The marks are correct.
No, the CB
1 minute, please.
May I-
And the ones who are above you have not been given appointment, and you have been given appointment.
That is an assumption.
I'm
Just one more item. So first thing which
No,
will
I'm
run the
not
investigation
saying,
of the case.
please,
It's
your
very
lordship,
hard.
kindly hear me out. I'm not saying your lordship should confirm my appointment. All I'm saying is, these are matters which ought to be relegated to the High Court because the High Court has not even gone into this. If very well they check my papers and they find, yes, I have
EC has
indeed
not found, had
jumped
to have
track.
an opportunity at least, if
He
nothing
did.
else. I'm not saying for everything.
What is
I'm not
the
reading that.
As per the OMR sheet, how many marks did you get?
Your lordship, I have different categories, so lordship, so many of them have been.
you would have simply filed an affidavit saying, as per the OMR sheet, my
I'm not
marks
trying
it was not
surely
considered.
wait, some status of that evidence is content. That is all I'm saying.
Y, Z. The minimum marks required for appointment were less than this. So therefore, my appointment was right. That's it.
Yes, precisely. Now, can I do this before the High Court? Because it has
So
never
please
been.
go ahead. Please, you should have done it before us.
But that is not,
Unless we are tested in the
I'm sorry,
trial,
Lord,
cannot face
that is
charges,
not
can
the-
have
as
it.
a fact-finding
Two
authority.
pieces separate
May I make a
investigation,
submission before the High
Yeah,
Court? These
you have to-
submissions were
Let's
raised.
not go around for remand on this.
No, no. Okay, if your lordship will just see page 17 of the commission's written submissions, table 2, where they themselves say how many are the OMR tainted candidates allegedly according to the commission. Now, CBI may have a slightly exaggerated figure, right, wrong, I'm not going into it. My first submission to your lordship is, your lordship is kindly consider segregating those who are tainted by OMR sheet allegations as opposed to the other allegations. All of them will thereafter get given separately, given to your lordship.
Please tell us if you have raised that point. We are not going to go into,
Your lordship, in which case, as far as my
you know the law, Order 41, Rule 27, you can raise additional evidence.
Yes, your lordship. In which case, your lordship, in one of my SLPs, which is Sanjukta Shashmal, before your lordship, item 1.2 part of 31 candidates. In this, your lordship will kindly see the allegation against me was that according to the sheets, I had got 1 mark extra, more than what I should have gotten. It is even the commission's own submission before the High Court that us 31 of the various people whose marks were exaggerated were actually within the panel. I'll show your lordship that so far as the 31 candidates in Sanjukta, in fact, my petition is still pending in High Court. I have filed it because all my appointments have been set aside. My matter has been rendered infructuous by the order. That is precisely my problem. If my matter is pending before the High Court, but because in this other batch of OMR cases, the entire selection has been struck
What is
down.
your case?
My case is as follows. My case is, I represent 31 candidates. We got interim protection. It was stated that the marks in my OMR sheet was a mark more than what I should have been given. Eventually, the commission before the High Court. And even after reducing the so-called 1 mark or whatever I got extra, the commission has taken the stand that 31 of us, and the commission is here and your lordship can hear them, are still part of the panel who fall within the execution criteria. Which is why we stand within the panel. I'm completely,
You will not be hit by, in your case, what is
Yes.
being hit you,
yes.
if you are being hit by is the complete destruction of the selection process.
Yes,
The
absolutely.
complete novation of-
Absolutely. So in that sense, in Sanjukta
No, you
Shamir,
are not-
Or a state
No, that is
government
one
as
of
an
my three
examiner of
cases.
electronic
Yeah.
evidence.
Not on both
Now,
the
my lord,
sides.
this has been done there by the central
Lordship,
government.
so this
At
is that.
different levels.
Insofar as group B is
Now,
concerned,
my lord,
the
there is no
allegation.
certificate.
Anybody else?
Milord, may I be permitted to, Milord? Yes.
I'm on a mismatch category.
But I'm for group D. I'm in the allegedly tainted people, my lord, although I say I'm not tainted. What I say is this, my lord. Group D, I represent about 300 candidates in group D, my lord, of rank jumping or any of these things,
If
except
passed
for the
for
fact.
the Formation Act, my lord,
Now, my
Section
lord,
155A of the Evidence Act,
the way that there's a mismatch between the.
Blank or forged?
My lord,
Blank or forged?
let me.
when it has not been. My second submission
to people such as myself. Those OMR sheets were then destroyed as per the rules within 1 year. Neither do those OMR sheets remain, nor does any copy of those remain.
It doesn't.
Nor,
give the
and
mode
this
of-
is very crucial, my lord, nor was any hash value
Your lordship
generated
has seen it.
at the time that they were uploaded. Only when we check and compare two sets of data to see whether the hash value is compared. And therefore to see if anything has been changed or
Let's not go
not, is to
around
generate
that.
the hash value in the first place, when they were uploaded. That has admittedly not been done.
But my lord, the
Therefore,
earlier the
if
judgment,
you generate a hash
earlier the
value
order which has
of
been delivered by.
hard drives which was
There is
found
some
with the
material
Pankaj
evidence
Bansal.
act, my lord, has been-
What will you compare it with?
material points
There was no hash value generated in the first place.
I'm just
Therefore,
going on.
there is no definitive way to tell.
You are then supporting.
Two questions which you then
complete
arise to your lordship says, what is the consequence?
Here the-
My lord, I'm serving. I was terminated and then under orders of this court, I'm under a stay. I have the job right now.
Okay.
I'm not reporting termination.
Just to
So
clear out-
therefore, what I'm saying, my lord, is
And after the IFT proceedings, what you have to say when the SEC itself has said so. Please see the submission, just see that.
No,
It's
it
not
has
been
not
obtained.
obtained. It has not
There's
obtained.
no FSL.
Special report has not been obtained.
I think forensic examination of the, has been done. The mega data has been there. Is there, you're wrong on that.
Milord, it has not been obtained, Milord, kindly.
It has been obtained. It was sent to the forensic examination.
may I-
I'm so sorry.
Milord, it has not been recorded.
My lord, therefore,
Declined.
my lord, I
They
want
have
to give,
declined that they would not do it.
an overall perspective
Yes,
as to what it is my submission. That is the question that your lordships are deciding at this sort of interim stage, my lord, when the trial is.
Okay, your case, the
Thereafter,
OMR
not in
sheet is
any other
available.
laboratory, it has
No, my lord,
proceeded.
Finding that
One minute,
the
your
hard
OMR
drives
sheet
have
will
not
be
been
available. The names are also mentioned, the
My lord, it is
signature
not-
of the candidate are also there.
With great.
So then if it's not there, then you'd have participated in the exam.
No, my lord, that is nobody's allegation, my lord.
Obviously.
At the time when I participated.
Okay, we'll know, we'll check up.
And just a couple of more things, my lord. Just on the overall perspective.
Thereafter,
That is what
it has not been, it has been
That
not
is correct.
sent to any other
That-
laboratory.
your OMR
Statement
sheet
and
is
file.
available.
This is not has been dated myself. There is manipulation. Kindly, my lord's done.
Scanned and uploaded that time were mandatorily destroyed for all
I'm
categories.
not on that,
Yes.
but the OMR sheets which they have been able to retrieve
Yes.
from the hard drive,
Yes.
your OMR sheet is not included in that?
They are, my lord.
Then
They are
why are you
included.
saying that they are not included?
No,
Milord, kindly
I'm saying that the
60,
original
65,
OMR sheets which were
2B4.
uploaded.
Forget it. The
2B4
OMR sheets
speaks
which
about
which have
who
been
will be allowed to
uploaded,
give this
put your
certificate.
OMR sheet.
Not
Yes, sir.
everyone.
And
That
you,
is how I
Milord,
got
kindly
the-
say this,
you
I
have to
am
then
coming to
file an
very
affidavit, this is not my OMR sheet.
I'm sorry, my lord.
You could have filed an affidavit saying this is not my
I've
OMR
sent
sheet.
you an affidavit, my lord.
It's not your, this is not your OMR sheet?
No, my lord, it's not.
You-
Even
it's
portions,
not-
I am not reading any 65
None
C.
of
The
you,
trial has
all
yet
of
to
you
start.
are
It starts
saying
at page.
your OMR
If
sheet.
they would just kindly turn
All
to
of
page
you are
16,
saying that
where
you
will you
cannot
see
be
these three
OMR sheet.
paragraphs?
I can speak for myself.
Purporting,
But
No,
just
the
excuse
300
me,
candidates
kindly
are,
read.
Yes, my
they
lord.
are all saying they're not their OMR sheet.
Yes, the OMR sheets which were found in the hard disk, found with Pankaj Bansal, are not our OMR sheets.
Okay,
And I've said that on affidavit.
thank you for supporting
Milord,
that.
is- may I just,
Milord, kindly excuse me.
Milord, may I just,
We are untainted,
Commission
we are
is
untainted.
regulates
Paragraph 6.
purporting to be signed by a
It is
person
stated.
occupying a responsible official expression to the
My
post-
category
Whose-
is
from whose
untainted
position
as
the
per
CD
para
were
6
recovered?
of
Sorry, the
State
hard
Service
disk were
Commission,
recovered?
tainted
From
as
whose
per
position
para
are the
7
Data entry operator,
of CBI.
according-
My
Read the
respectful
CBI
submission is I
report.
respect.
Whether Pankaj Bansal name is mentioned there.
Okay.
Milord, the two other
9th and
persons,
10th or 10th
Milord, who
or
are the
11th and
persons
12th, Milord.
in charge
11th and
of the
12th.
operation.
So therefore,
They
as
were
per
there.
State
Certificate
Service
has not been
Commission,
obtained from them.
I don't
Certificate
fall foul.
has been obtained
Para
from a
6.
person who
As
has
far
left the
as
company and went to
the other
someone.
category is concerned, Milord,
This is there from the
OMR,
report itself.
I adopt the submissions of Mr. Sundaram, Milord. That these require further investigation, these need to, and that was the submission of Ms. Padmanabhan also, as well.
Milord, may I just
In the
take 2
affidavit,
minutes,
5
Milord?
places the
I
CBI
have a
says
partner,
investigation is that honor carefully scrutiny. My lord,
may I
let me
take 2
say
minutes,
straight away.
Milord?
I know
Milord, I have
these
a
assistant
partner
teachers.
going on. Sorry for this, Milord, mine is a case where we were working in the education department from 1999 till 2016 when this advertisement came. The system earlier in West Bengal was that there were 5 zones and you could only one zone and could not go all over. The rules were changed in 2016 allowed that you could be placed anywhere, even near your hometown. So Milord, we took permission and we were granted to take the examination for the purpose of being taken. We were then again in panic and our service books were Milord continued from before. Our salaries were fixed according to the old service and there is no taint on us here. And we filed an application for intervention before the High Court. The High Court wrote that an application is filed after it is made, but does not go into it further. And we are Milord, 1% going to retire coming year, 2025. We are from 423 odd people. My application number is 1.19. Respect to the lordships
I
today.
not just bear with that category. I saw further given then, my lords. I'm not wrong.
Paragraph. you are.
2806 also. 287
No, we-
goes on what? CBI, because your lordship said there was a comparison between SEC
No,
and
in the,
CBI.
my lord, in the tainted list, we are not there at all.
We understand.
And we
My
are
lords,
continuing
so
to work
while
today.
they find that,
Therefore,
the
what we are
OMR, as
saying
my
is
lords
you are
may
not in
imagine, we've all
agreement.
done multiple
Yes.
choice tests.
Because
That
we are
is the
annulling
version of the
we
email.
uphold the judgment
Now,
and
what is
annul
the hash
recruitment
value that they
process.
have
Yes.
compared?
Your
It is
services as
not
they
the
exist
hash
prior
value
will
of
not
every
be
individual
We-
OMR.
That's all.
What
That-
they
I'm
are
very
saying-
obliged for that
We
observation.
cannot.
Very
They-
grateful.
Okay.
Stand in the same footing
Very
as
good.
Mr.
Kumar has,
Documents
my lord,
must be
I am,
contained in one file itself.
Lordship, I am in
SEC
similar category. I am
CBI
completely
says,
untainted. I am
even in the
nowhere, my lord.
investigation,
What they
and
have
it has
done
been
is-
methods,
Or
data
show
scam,
anywhere.
you remain
The
valid.
issue is, I am 1.72, my lord,
The CBI
47.
watching earlier.
Yes.
Whether
I
the
was
hash value is
employed
different.
property was
Petition
not.
of scanning, the process data into the main scanned images,
But as my
scanned
lord
data
I
was
support
handed over.
segregation.
While
Lord,
data
I
scan,
class
investigation
when
by
they
CBI,
extracted
it has been
the
alleged
data from
when
OMR
alleged
To the condition and
into
case
a
be
dot
annulled,
dat
except the
file.
annulment of recruitment.
There is,
My
and
lord,
I
my lord,
researched this
second-
extensively.
to be manipulated
Secondly, my
by
lord,
allegedly
secondly, I just wanted to add
manipulating
there are
OMR's
generations.
own
My lord, I
effort,
just
that,
wanted
and that is
to
where there are
excess
also
appointment
educated
and
in
supernumerary
Not
post
in-
that was being
not today as
argued
much, but
that
in
time.
2019
That
or
only relates
2018.
to, as per my
We used to
instruction,
convert
Group C
PDFs
and
into
Group
Word
D.
files.
This has
Now,
nothing
errors-
to do with
Now, my lords, what
class
they've done
11,
is
12
pointed out
and
3 to 8
9,
who
10.
were appointed.
They have
So
all
the
these
point I'm trying to make, my
constraints
lords, is
that
whatever
they
it is,
themselves created.
So
Dissimilar
that
should
issue
not be
And
chosen.
then
may
you
not
have
be
What is
these
leading these
brought
laws?
in with the
with
teachers, my
not
lord.
one generational loss,
That's
but
my
two,
respectful
because
submission.
there's the
But the
dot
teacher-
dat file.
I am teacher, my lord,
that
class
then
11,
becomes
12.
the dot
and
DBF
page-
file.
In
third
volume 2
file.
of my
And then you compare the
SLP,
hash
my lord.
values, my
This is
lord.
1.72.
And so the thing is
I have
that-
given
We have
complete
already
chart.
said, if you want something more.
No,
we
my
can
lord,
extend
what I'm
this.
saying is
The
this.
High
What
Court
I'm
has
saying, my
thrown out
lords, is that
everyone,
of course all may
13,000
not be
people.
well in the state of Delhi.
Yes,
I'll
please.
take
Of
only
course.
1 minute.
That's just a fact.
Officer wrote
Finish
class
your-
CAD.
Now, my own submission
I'm
to your lordship, subject to
in
what you
the
feel, my
9th and
lords,
10th.
is that SEC has found that
No, not
these
in
categories,
in
board handed over
clerical
their laws and not at all in the
I'm
panel
an
respective
assistant
points
teacher
of course,
in
Johnny
the
Rank.
Okay, 9th page is the.
I'm
Now,
80
my lord, there
assistant
is
teacher.
no allegation of rank jumping, etc. in my case. Therefore,
My
my
lord,
lord, I
I
say,
believe
if at
I am
all
not
any
tainted.
segregation should be done in this case, it should be that the people
My
against
lords,
whom
as
there are
per the
allegations
order,
of
there are
OMR
two
mismatch,
three types of tainting.
they should be allowed to continue for the
And
simple
all
reason
three types
that
of
in
tainting
order
are
to
based on
distinguish
entirely
what is
different
a genuine OMR and what
So
is not,
I
what is
am
being
there
found with
only
Bansal,
third category.
only
So
a
when we
trial
look at the
where a
first
forensic expert is examined will
where
make
the
that clear.
OMR is being
Whereas
challenged.
that is not the case, it's not the
So, my
complexity
lords,
of
what we are
the
saying-
process required in the
So
other
what
cases
we
of
are
rank
saying, my
jumping.
lords, if I
That can
may
be seen much
just
more easily now.
point to the
Because as
differential
per-
in
That's
the
all they
value
said.
of the evidence
Okay,
between
now that's
the
over.
people
let's
who
take
are
the
alleged
next
to
one.
have jumped
My
ranks.
lord, I can understand.
I'll take
But
only
regarding
5
others where at that evidentiary stage, surely, my lords, we will have to be subject to whatever is decided finally, whatever
But
this
my
evidence
lords,
is.
raised a question earlier, if I may.
any reckoning. By any reckoning, I'm untainted.
But my lords, the things that are apparent, the ex facie
Volume
wrongdoing with the
6,
rank
page
jumping.
92 is my written submission. I'll take 5 paras only and your lordship will see how grossly the injustice is. I am
All I'm saying
untainted
that
according to
face
CBI,
value
according to everybody, according to the board, according to the government. I just turn to
Whatever
page
it
92
finally
of
brings
my
out
Either the
the
criminal
5 paras
process
only,
is
I'm done.
Pankaj Bansal is
7,
going
8
to
minutes.
fall under cross-examination.
Yes.
All my lords,
we've got
let
page
it go through
92.
the 2018 rules.
Now, the petitioners were bona fide applicants to a public advertisement for recruitment in 2016, participated in a competitive examination, received the recommendations and were issued appointment letters. They were appointed validly and remained in undisturbed service between 18 and 19 prior to the expiry of the panel in December 19. We are class 9, class 11, 12 out of 4 categories on these assistant teachers which I have given in para 2. Para 3, no adverse action has been taken against me. It's very important. During the course
Six
of
I
hearing,
can understand is
before
one
the
category,
Honorable High Court
but
from
you cannot
2021
mark
onwards,
7 in that category and say even 7.
interim direction was passed in
in the impugned judgment.
I'm
It's going on for last 3 years.
Okay, let's
Further,
have,
the petitioner
let's finish with the
did not feature
tainted
in
first.
any
then
of the
we go
list
to-
of tainted
Requires no
categories.
inquiry
Justice Kumar
whatsoever.
asked a direct question.
That is
I'm
all
giving
I
an
want to
unequivocal
submit,
answer.
my lords, yes.
No
Number one,
category,
let
no
the
list
baby
by
now be
any
thrown out
entity.
of the bathwater because-
None. There were filed
No, no,
last
let
time by
everything
CBI
not
and
be
West
set
Bengal
aside.
Central School
Two,
Service Commission before the
amongst
Honorable
those
Court.
who are
Underscoring the
found
soundness and
whoever
legitimacy of the
displayed
appointment of
possible
tenure. Thus, despite there being sufficient material before
Are
you to
different
identify and
allegations.
separate the
In
tainted from
group
the
D,
untainted,
they say that
such as
I'm
the
not in the
petitioner,
panel.
the
And there's no
impugned
recommendation
judgment
given by
erred
the
heavily
commission
by
where the board
painting
who's
all
appointed me
candidates with
says
a broad
commission
brush.
can give
Prior to the initial order, I am nowhere in
Second
any
category is
list.
rank jumping.
It is
Third, they
also
say there was
crucial
some
that a vast
tampering with the
majority of
OMR,
them,
but
I'm
commission says
10,000
even if that one
working
mark
from
is
2018.
taken care of, even then they,
Now, let us kindly
31
come, and
candidates make it
as I
to the
said, I
panel.
will
I'm
just
part
come
of
to
that
para
31
15.
candidates. So there are three separate
I'm skipping
categories.
most of it.
My submission to your
I'll
lordship
come to
today is
para
as
15
follows.
now.
What has the High Court done? The High Court has
The appointing authority and the recommending authority have
irregularities
because of
the OMR
the
sheet.
expert body
Insofar as
involved in
rank
the
jumping
recruitment
out of
process
panel, there has been no
found it
discussion,
fit to
nothing.
separate
Your
the
lordship started off
tainted
this
from the
hearing wondering if
untainted.
there's a
Why,
possibility
Malas?
of segregation.
For a very
And
simple
I'd like to
reason in my
address on
case,
that.
which is
The
given in
lordship will
para
see
16.
the commission
There are
has written
three
something.
lists
I'm
made available by the
now
board
at
and the
page
CBI.
17, your lordship, that is
These are the list of
seven
kind of
775 of the commission.
All I am seeking
is
that regarding these people,
there is a
both 9,
kind
10 and 10, 11 classes. List of 942 whose OMRs were found by irregularities, nowhere on the list. I am nothing of this. List of 907 whose OMRs
I'll
were
tell you,
found with
Lordship, as
irregularities
far
for
as
11th
there
and
are
12th.
two of the three
The
categories.
first
Just
list
so-called
pertains
rank
to the
jumping
independent
and
exercise
so-called
carried out
did
by
not
the
get a
board
recommendation from
of
the commission.
classes so and so.
According to my exhaustive
And this lordship
recommendation,
knows
there has been no
Next,
rank jumping.
fourth
So
line.
these two issues
Notably,
are
the
purely
CBI
factual and
had
they can be
filed an
segregated from
investigation. This is
OMR.
very important,
As
lordship,
far
outline
as
this.
my omnibus submission
Saying
is,
that the
lordship will
investigation
consider
relating to
that even
all
the
four
CBI
categories was
commission
complete and
is
charges
going
have been
to
filed. They found those four categories, I'm nowhere there. It's over. And even before the High Court, as far as illegalities are concerned, your Lordship, I made a table. Your Lordship has heard the OMR manipulation issue. Your Lordship has heard the OMR issue. Your Lordship has heard rank jumping. Next page, page 94. My Lord has heard expiry of panel. And my Lord has heard beyond the advertised post. I am nowhere, completely, unqualifiedly untainted. Para 19. In fact, the High Court acknowledges in para 329 that the
big deal
percentages
comes,
of
no, your lordship,
manipulated
the big
illegally
deal is, I'll
appointed
tell you,
persons across the categories other than Group D are on a reducing stage. There were no other information available before the High Court. It's only the High Court which has done it. Nowhere have I been touched earlier. Now just 2 minutes more. Item para 3 Under that one, High Court makes no effort to separate the tainted from the untainted. Come straight to para 22.
No. I have not been given. Two
The
of
High
my
Court,
three
this is a
cases
blanket
of no
approach,
allegation
throwing the
of
baby out with the bathwater, completely blanket. The High Court proceeded with option C. C is the cancellation of the entire
allegation.
selection
It's
process.
the allegation. Now, may I submit?
Your Lordship, I would say our obliged should be, if your Lordship finds the untainted categories, the High Court did not do, is my humble
Please, my lords, mold the
So my first,
based on the entire selection according to the High Court. Because it is difficult to separate the chaff from the wheat. That's the main reason given. However, no effort is made by the High Court to separate the tainted from the untainted, despite abundance of material available. In Kalon's case, the court laid down the standard of absolute impossibility. I have given that at page 40, para 43 of the judgment was. Only in case of absolute impossibility. Convenience is not a defense. Careers of 10,000 in my class.
If very well
will
they
be
check
spoiled.
my papers and they find,
the
yes,
answer
I
comes
have
is
been
convenient to separate or segregate.
He did.
I'm not saying for everything.
Then Malas 24, the aforesaid list provided by CBI and the board have not been adverted to. Well, if the High Court is passing a blanket order unseating me, then it had to at least say that where are you? No exercise. Para 25. In para 325 and 336, there is a whole bunch of paragraphs. High Court holds that the original OMR sheets are not available with the board.
Yes, precisely. Now, can I do this
exercise
before
of
the High Court?
sifting the
Because it has
grains is
never
not
been.
possible.
You should have done it before us.
Is it somebody's fault? Is the original not available? You have from the CBI. How is the CBI made the list? How is the board made the list? They could put up the hand and say, all 10,000 you get out because we don't have the original. That can't affect my career. I'm completely outside the system and completely blameless.
Table 2.
Then Malas in
Where
para
they themselves say
29.
how many are the OMR
dealt with
tainted
Kalon's
candidates
case,
allegedly
which
according
I've
to the
already made, I'm
commission.
not reading it.
Now, CBI may have slightly
Kalon's case has three more judgments.
I'm not going into it.
Not punish cases, not blanket club and throw me out as three judgments. Kalon is the three-pronged juristic principle
is the three-pronged
We are
test
not
of
going to
Kalon.
go into-
1, 2,
Your
3 I have
Lordship, in which
given.
case, as far as my,
I'm not reading it to save time. The three-pronged test is very clear. The High Court doesn't apply any of these three-pronged
yes, Your
tests.
Lordship, in which case, Your Lordship, in one
And
of
then
my
lastly,
SLPs,
Malus
which is
is,
Sanjukta Shashmal, before Your Lordship.
onwards, very club,
31
group
candidates.
C, D,
In this,
and
Your
Malus
Lordship,
everybody else.
will kindly see,
Malus, I would
the allegation against me was that according to the sheets, I had got 1 mark extra, more than what I should have gotten. It is even the Commission's own submission before the High Court.
You're here,
that
fortunately,
us
you have an
31 of the
individuated
various
approach.
people whose marks were exaggerated were actually within the panel. I'll show Your Lordship that so far as the 31 candidates in Sanjukta, in fact, my petition is still pending. All my appointments have been set aside. My matter has been rendered infructuous by the order. That is precisely my problem. If my matter is pending before the High Court, but because in this other batch of OMR cases, the entire selection has been struck down.
Your case.
My case is as follows. My case is, I represent 31 candidates. We got interim protection. It was stated that the marks in my OMR sheet was a mark more than what I should have been given. Eventually, after reducing the so-called 1 mark or whatever I got extra, the Commission has taken the stand that 31 of us, and the Commission is here and Your Lordship can hear them, are even part of the within the panel. I'm completely.
You will not be hit by any in our case. What
Yes.
is being hit you?
Yes.
If you are being hit by is destruction of the selection process.
Yes,
That's being
absolutely.
complete ovation.
What is state
No, that
government
is one
as
of
an
my three
examiner of
cases.
electronic
Yeah.
evidence? Now, look, this has been done there by the central government.
So this is
Different
that.
level. Now, Milord, there is no certificate.
Anybody else?
Milord, may I be permitted to, Milord?
Yes. I'm on a mismatch category. I'm for Group D. I'm in the allegedly.
Lastly, one thing, only one minute, only less than a
But I
minute.
say this.
Para 30, I forgot to
Group D,
read.
I represent
Just
about
note
300
30.
candidates
That's
in
the
Group
4
D
lines of 30 are very
of
important.
rank jumping.
There are
Or
no
anyways, they
findings in
accept
this regard
For
as
this
far as the
permission,
majority of
Milord,
appointees.
from the
No, next sentence, as far as teaching staff is 8% and 14% now.
Fact or forged? That's not the point.
That's the basic argument. I'm not at all involved in it.
People such as myself.
Even if
Those OMR sheets were then destroyed as per the rules within 1 year. Neither do those OMR sheets remain, nor does any copy of those remain.
apply the principle that
Nor, and this is very crucial, my lord, nor was any hash value
Milord, I
generated
just-
at the time the and therefore to see if anything is being changed or not, is to generate the hash value in the first place, when they were uploaded. That has admittedly not been done. Therefore, if you generate a hash value of hard drive, there is some evidence that admittedly with various points to the
Objection is that there is a material to segregate. The
Those
materials are there. What else do you need to segregate?
Two questions which you then raised.
Because in 4 years,
What is the
the
consequence?
CBI could be in some list, the board could be in some list, the SSC could be in some list, whereas I can't prove a negative list. They've been doing lists for the last 4 years.
Just why I'm appearing in 1.11, I'm in the same category as Dr. Singh. I just one small submission break, it'll take 30 seconds. That is, the CBI has got the material from the hard drive. Having got the material, they have segregated themselves because they have said that 92% in 9 to 11 are not taken, but 8.24% are. And as far as 11 and 12 is concerned, 14.57 are, 86 are not tainted. So the CBI has done that exercise. And having done that exercise, then we can't be punished. And I'm in the same category. And the rich court, what it does, it takes C and D category. The other category where it is 30% and 40% tainted and clubbed it together. Instead of 19,000 people, of 19,000 people, 8%, 14%, I'm going to take an average of 12% are tainted. You you will throw out the other 88% because 12% are tainted.
Then if it's not there,
I've understood your argument because CBI itself has
Bifurcated, correct.
Yes, they have
Lord,
done. That's all.
I am in the same
Okay,
category,
we'll
my lord.
check up.
I am in the same category as that of Mr. Sibi and Mr. Sibal, my lord. Only difference is Group C and D I represent, my lord. My SLPs are at 1.5 and 1.13. My submissions are at page 100, volume 6A. But my submission is that, like your lordships have noticed, from para 2 till 309 of the impugned judgment, the High Court has taken note of the segregation information that has been given, my lord. In none of the reports that our names have figured. We have been appointed in the first list in April 2018. From then, there is no material, nothing is till date, till the impugned judgment. We have not been called upon to do anything. Our name is not mentioned anywhere else. Now the point here is, if the High Court holds that the information is admissible and we have got enough information to segregate the names from the tainted ones from the untainted, and if this kind of direction at page 272, para 363, the direction number 4 will say that persons who have been appointed outside the panel, after exchange of the panel, as also those who submitted blank OMR but obtained appointments must return all remunerations and benefits received by them in the state exchequer along with interest, etc. My lord, if this kind of information can be taken and their appointment can be set aside with the same kind of information, my lord, how can the item 2 order can be passed? Not all appointments granted in the selection
We are
process
untainted.
involve this violation of 14 and 16. So all are different and not one. So this direction, number 2 not cannot stand because there is enough material with the CBI and also not in all the affidavits which are placed before the High Court, which your lordships have seen. And secondly, not like Mr. Singhvi was pointing out, interpreting column really says not there are 3 places which I have extracted in para 2.3 of my submissions, which exercise has not been undertaken by the Honorable High Court, which says not which I read, if the services of the appointees who have put in a few years of service were terminated, compliance with the three principles in the hands of the state are imperative. That is, to establish satisfaction in regard to the sufficiency of the materials so as to enable the state to arrive at its satisfaction that the selection process was tainted as per them. To determine the question that the irregularities committed go to the root of the matter,
May I just
such satisfaction as also sufficiency of the material that required to be gathered by reason of a thorough investigation in a fair and transparent manner. Whether the sufficient material present enables the state to arrive at the satisfaction that the officers in majority have been found to be part of the called purpose or the system itself was correct. None of these will not have been carried out. And para 93 says it is one thing to say that having regard to the nature of the selection process, no person is appointed from the select list as no person has the right to be appointed only because his name appears in the select list. But our opinion is a different standard must be adopted for terminating the services of the officers who have completed about 3 years of service in that list. Some of them have noticed very report passed perfect test. Some have been given high responsibility. They have completed period of probation or somewhere nearing the completion thereof. They presumably have been working to the satisfaction of the authorities. Same period from 2008 till C and D. No action against us, not needed, no names have come out. We have all altered our position in society. We have improved our lives and we have some of them have created loans, etc. Their rights to work, they have not been part of the commission. We not in para 2.5 against all of what you judgment in Rajesh you say that bodies of one is that it's only subsequent. It's not a case where massive fraud is said to have fallen in the electoral process, in exception or in the conduct of the examination itself. Furthermore, the untainted candidates job after work for 6 years without complaint of
Malas, I appear for the tainted list, we are not there at all. Malas, I appear for the
So while they find that the OMR has been called on multiple choice test, that is the version of the argument. Now, what is the hash value that they have compared? It is not the hash value of every individual.
That's all. I am very obliged for that observation. Very grateful.
Kumar has,
The committee of the retired judge of this honorable
I am
court,
a
the
seasonal
technical
category.
expert from
CBI,
NIC,
even in the investigation,
The issue is I am 1.72, my lord, 47. Yes, I was employed to
the process data into the main from images as per
I support segregation.
by data scan investigation by CBI, examine and data someone when alleged
Not named by anyone and even of government jobs come to. There is an second to be manipulated.
I appear for the
That only relates to, as per my instruction, Group C and Group D. This has nothing to do with class 11, 12,
paragraphs of that statement, and I'll show no concept of point I'm trying to make is the central point of debate here. This is only
One generation.
Para 3 and
That's
5.
my respectful service. There's the dot that.
I am teacher, my lord,
That
class
then
11,
becomes a
12,
dot
and
DBF file.
in volume 2 of
And then you compare the hash values.
This is 1.72.
And so the thing is
I
that
have given complete chart.
The scanning of OMR sheets was undertaken by the same Communications Private Limited, at the office of the SSC, Acharya Sadan, under direct supervision of Shri So-and-so, Niladi Das. Lots more, but the rest kindly come to fifth line from thereafter. After completion of the scanning,
is that SEC
the process data in the form of scanned images of the OMR scanned data, etc. were handed over to Data Scantech, handed over by Messrs. Data Scantech Solutions to NASA Communications Private Limited, who did the same to their office located in Noida in digital form, reading the usual hard copies of the OMR sheets in the office of the WCSCC, handed over their answer keys in respect of all subjects to NASA Communications for evaluation of OMR responses. So bear in mind, Lord, NASA was never a party anywhere, nor was it raided every time, nothing was recovered from them. Now kindly have para 11.
What we are saying, what we are saying, my lords,
That can be seen much more easily. That during investigation, data files containing scanned OMR, DAX files, etc., pertaining to the aforesaid SSC recruitment matter for all seized from Messrs. Data Scantech Solutions. Now kindly see the conflict between this paragraph and that paragraph. They handed over everything to NASA and they took away. Now here they say they're comparing
raised a question earlier as
Untainted by any reckoning.
data
Any reckoning, I'm untainted.
Scantech
So that's why
Solutions.
things that
Now
happen
again
in
in
the
paragraph
volume 6, page 92
41,
is my written
paragraph
submission.
18.
I'll take 5 paras only and your lordship will see how gross
Messrs.
these
Data
injustices
Scantech
is.
Solutions
I am
made the initial scanned
untainted
images
according
of
to
OMR.
CBI.
These scanned images were given to Messrs. Dasha, Pankaj Bansal, detailed copy of the scanned images. Now, Pankaj Bansal is not at this point of time was not the employee of NASA. He seems to, he had left NASA and was post over by the supervisor. Now, where does this come? Kindly just for a moment, Lord, that page,
recommendations and were
Lord, should compare it with the first
They were
report.
appointed by
The difference in the first and the second report. The first report also comes
prior
post
to the
Lord
expiry of the
detection of
final
the
petition.
three artists. 3 months after that. And there they said, Lord, paragraph 5, only page,
On these
this is paragraph
para 2.
253.
During the course
Six I can understand is one category. What were they matching with? Can we have not paragraph 5 and page and paragraph 253?
going on to last 3 years.
Okay, let's finish with the tainted first.
Any of the list of tainted categories, Kumar asked a direct question. I'm giving unequivocal answer. No category, no list by any entity.
Everything not be all the data itself, all the data was handed over.
Underscoring the soundness and thus, despite their insufficient material required to
different
identify
allegations.
the data,
In group D, they say that I'm not a panel.
No, all that data was handed over.
erred heavily by pain
board whose appointee says
prior to the order, I am nowhere easily
there is rank jumping. Third, they say there was some tampering to OMR, but commission says even if that one mark is taken care of, even then they 31 candidates make it to the panel. I'm
just
part
come
of
to para
that 31 candidates. So there are 3 separate categories.
most of it.
My submission to your lordship
Come to
today
para
is as
15 now.
follows. What is the High Court has? The High Court has
Expert body is separate
started from the unpending. There's a possibility of segregation, and I'd like to address on that. Lordship will see, the commission
There are 3 lists made available by the board and the CBI. These are the
seven kind of inquiry. The commission I am seeking is regarding these people. There is a
Item 1.38, I represent the all
OMR were
Bengal
found by
blind
Irregularities
teachers
nowhere on
association.
the list.
There are
I'm
18
nothing of
blind
this.
teachers
list
totally
of
untainted.
907.
But the two additional
whose
points is
OMR
one
is
for
Mohammed
Mohammed
irregularities
As far
for
as
11th and
challenged.
12th.
two of the three
She has been
categories.
exempted
That
in
is
paragraph
rank
16
jumping
to
and
360
the
additional
expiry
standards
not get a
for
recommendation from
The
the
second is
Contempt.
the
And
person's
his
visibility.
realize there has been no rank jump.
This
So
line.
these two issues
Notably,
are
the
purely
CBI
factual.
had
They can be
filed an
segregated from
investigation.
OMR.
Very important.
No,
As
not
far
just
as
because.
my omnibus submission.
No, but
that
we are
the
totally untainted.
investigation
We don't
relating
forget
to
this.
all
We are
those
just saying
categories
from
of
the
illegal charges in the file.
No, no, but
So,
no, no, it's not new
before the
category.
High
The
Court,
great resistance
as far as
the High
illegalities
Court
are
has
concerned,
recognized that
Your
Soma Das
Lordship
is
has
a
given-
challenge.
Your Lordship has heard the OMR manipulation issue. Your Lordship has heard the
No, no,
OMR
well,
issue.
may I just point out
Your
two
Lordship
more
has heard
things.
rank jumping,
Person's
disability
visibility.
94. My Lord has heard expiry of panel, and my Lord has heard beyond the advertised post.
No, but let's, all your lordships will have to
Nowhere
see is,
completely
do they figure in any of the
unqualifiedly
lists at all?
untainted.
No, no, and the
Para
other
19.
thing, well, let's,
In fact, the High Court acknowledges
No, no,
in para
this, no,
29.
No, no, Malad, may I also say
No,
this,
Your Lordship,
four
the
of
big deal
them
is
were in
I'll tell you.
service,
Across the
they had applied
categories
for
other
these
than
exams for
group D.
upgradation.
There was
What's the
no
third
other
cat-
information
the
available
third
for the
aspect
High
will
Court. It's only the High Court which is
many of them
concerned.
were given
Nowhere
age
have I been
relaxation
touched
because they belong to
No, no,
Now just
not
2
at all,
minutes
not
over.
at all. They just mixed up.
Para to separate
marks
the
are same.
tainted from the untainted, come straight to para 22.
Only two
No, 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 no. I have not been given.
The High Court is a blanket approach, throw the baby out with the bathwater. Completely blanket.
results are given, there
The
is
High
no.
Court proceeded with option C.
No, not,
C
there
is
is
the
no.
cancellation of the entire
allegation.
selection
Is the allegation. Now may I submit?
Your Lordship, I would say are obliged to convene if Your Lordship finds that stability carries with the High Court and not this issue by humble.
Please, my lords, hold the
So my first,
Because of the Bansal Lord Raid, the hard disk is discovered. I'm a part of the untainted. The hard disk is discovered. So there is a issue with regard to
However, no
some
effort
people
made by the
whose
High Court
marks
to
have
separate
been
the tainted
altered.
from the
Otherwise, Lord, there is no way of identifying
untainted.
those 900 and whatever. Because the identification only takes place because they find that there is an alteration. Obviously, Lord, the sequel to that is that for the others there is no alteration.
Convenience is not a
There is no other
careers of 10,000 in my class.
if very well they check my papers and they find yes, I see it,
last
then
year,
you jump
opportunity.
If they
I'm not saying for everybody.
Then was 24.
Maybe
the
across the
offset
board.
list provided by
But I
CBI
have
and the
different
board
categories
have
of
not
discovered
been
that the
adverted
lordships
to.
have held in some judgment, then the whole exam has to go. But if the taint is such,
Then it had to at least
where
say
the basis of the taint itself is alteration of some people's marks, then that can't apply to people whose marks are
Para
not altered.
25.
So my
In
respectful
para
submission, Lord, as far as we
325
are
and
concerned, we are
336,
doing our
there
job
is
for
a
last
whole
6 years. There is no
bunch of
taint
paragraphs.
as far as we are
High
concerned.
Court
Our marks
holds
are
that
our original marks.
OMR sheets
For
are
the
not
subsequently
available.
altered marks, we are not
precisely.
altered
Now can I do
marks.
this
Yes,
before the
sir.
High Court because it has
And
never been.
if there had been no basis, Lord, of having an original mark, then there could not, Lord, have been a basis of finding somebody's marks to be altered or somebody is not given selection who was beyond Lord's merit. So there are two categories of taint. One
That
is
can't
Lord,
affect
marks
my
are
career.
altered. The other is people who are lower in the merit system.
And completely blameless. Then
Both those categories are identical.
How many are the OMR
And both
tainted
those
candidates
categories are put in
allegedly
that
according
table.
to the commission?
Not reading
Now,
it.
secondly,
We are
Is the three-pronged test of Kalon.
Lord,
1, 2,
that's
3,
what
I
I appear for
I'm
the
reading it to same time. The three-pronged test is very clear.
148%.
The High
Now,
Court
that is
doesn't apply any of
comprised
these
of some
three-pronged
visually
tests.
challenged
In which case,
persons,
Lordship, in one of
some
my
persons who were already in
Sanjita
service,
Shashwat,
and
Mr.
all are
Lordship.
untainted. So I only want to say
One
that
candidate.
paragraph
In this
And
stated
one of
what
them
you
is
do in judgment.
kindly see
I would
the
The High
allegation
Court, my lord, I don't
against
say
me
on a
was
very
that
reasonable
according
ground,
to the
took an
sheets,
exception
I had got
on
1
the
month
ground
extra,
that there is a
more than what I
medical
should have
condition
got.
of a
It is
girl
even the
named
commission's
Soma
own
Das.
submission
In
before
her
the High
case,
You're
Court.
here,
exception is
fortunately, you have an
31 of the
individual
various
so far as
people
we are
whose
concerned, my
marks
lord, we
were
are only
examined
trained before your
were
lordship
actually
that
within the panel. I swear, Lordship,
fundamental
that
principle,
so far as the
all
31
judicial
candidates
system
is
that is being
in
followed.
fact, my
Like
petition
one hand, your lordships try to ensure that no illegality is perpetuated,
all my
no
appointments have
difficulty
been
for
set
that.
aside. My
On the
matter has
other
been
hand,
rendered infructuous
if
by the
lordship
order. That
finds
is
that we
precisely
are
my
the
problem.
honest and
If
the
my
innocents,
matter is
we are the
pending
victim
before
of
the
the
High Court,
situations
but
because we
because
are
in this other
completely
batch of
non-tainted.
OMR cases, the
And that
entire
too in a
selection
has been
judgment and
struck.
humanitarian aspect has been
My case is as
incorporated.
follows. My
My
case
lord,
is, I am
since we are
representing 31
completely
candidates.
untainted,
We got
lordship may
interim
carve out an
protection.
exception as far as
It
we
was
are
stated
concerned.
that
But
the
this is my
marks in my
fundamental
OMR
subject.
sheet
May I-
was a mark
repeat?
more than what I should have been given. Even to
I made a note also, my lord, at page 94 only.
May I-
reducing the so-called 1 mark or whatever I got extra,
which is the
the
foundation of
commission has
everything.
taken the stand that
Itself,
31 of us,
raises
and
large
the
number of
commission is
questions
there, your
which
lordship,
impacts
any
the
of
entire
them.
category. So I am unfaithful. No, don't go anywhere. But the fact remains is segregation by one does not have the legal authority,
Within the panel.
nor
I'm
the legal
completely-
capability to give the certificate under 65B of the Evidence Act.
Yes.
Millets, for the very simple
Yes.
reason that he does not fulfill the conditions under 65B
No,
or.
he's actually, it is not required.
Yes, absolutely.
In this case,
Or a state government as an examiner of electronic evidence. Now, this has been done by the federal government.
So this is
Millets, I pause for a minute. Now,
May I be permitted to
the issue.
really is not required in this.
Millets, with utmost respect, if he addresses this entire issue of the certificate of 65B, then the entire controversy will stand will be standing settled once and for all. Millets. Because the question is,
there are
the
no
original data
findings
belongs to
with
the
regard
the commission asked the ISA to address, there are only two legal entities.
Next, as far as teaching staff is 8% and 14%.
You had taken that, who had
Millets, but with utmost respect, when one reads the certificate, there is no reference to the condition that is described before. Also, Millets, it's nobody's condition or nobody's case that he was the one who was. Millets, I am only on the limited point of not even 65, on the limited point of the certificate. So the certificate is being given by a person who does not have lawful authority over the original computer records. The original computer records were a thief. The question is, he's only a thief. He gets unauthorized access. Millets, at the end of the day, it's something like somebody comes and steals something from my house, and I find something is found here. Millets, the question is, there is no original hard disk.
Look at it careful, there is a contradiction emerging.
Millets, when
Because 60.
What is the questions which you did?
Whereas I can't prove a negative. They've been doing this for the last 4 years.
Millets, in this particular case, when I come back to Arjun Pandit Ravkotkar, what they are saying is that this is a complete code. So, Millets, in this case, when you look at the certificate does not say how is it custody, number one, because this is Millets, what is in possession is not just what is in possession is also not a copy. What is in possession is tertiary evidence, which is not constitutional of the evidence.
And as far as 11 and 12 is concerned, 14.57 are 84 are 86 are not tainted. So the CBI has done that exercise, and having done that exercise, then we can't be punished. And I in the same category. The rich court, what it does, the other category where it is 30% and 40% tainted, and clubs it together. Instead of another 19,000
initiated re-examination and everything, reprocessing. So, Lordship kindly exclude us from this.
12% are tainted.
Lordship, I got the rating of 1.37. I am in the same category, my lord. I am in the same category as that of Mr. CP and Mr. Sibal, lord. Only difference is group C and D I represent. My SLB
should be selected based on the previous election. So, my lord, one is an age relaxation because this only goes up to 40 years. Now, 10 years have gone by since the last.
From para 2 till 309 of the
Second, my lord,
the High Court has
I
taken
requesting
note
is, my
of
lord,
the
may consider
segregation
to restrict the
information that has been
examination to
given.
those people who have
In none
taken
of the
part
reports
in the
that our
first
names have
examination
figured.
in 2016.
We have been
That is all I am
appointed
praying, my lord,
in April 19,
modification of para
2018. From then,
360.
there is no material.
So,
just may I with your lordship,
We have not been contemplated. Our name is not mentioned anywhere else. Now the point here is, if the High Court holds that the information is admissible and we have got enough information to segregate the names from the tainted ones from the untainted, and if this kind of direction at page 272 para 366, the direction number 4 is saying that
the possibility of exploration with regard to Roman 2 is the segregation. Now, where I stand, my lord, I am the candidate who participated and are not called for. Interestingly, my lord, there is what I understood from the understanding of the segregation part. So far as the affidavit filed by the School Service Commission, there is an unequivocal admission from the School Service Commission with regard to certain irregularities with regard to rank jumping and etc. which has been enumerated prior to my submission. But taking a cue from that, if there is such irregularity which is apparent on the face of the record, and there is an admission which is unequivocal, my understanding is subject to correction, there are nothing beyond that. That irregularity can be rectified at the threshold. That is one glimpse of my submission. So that rectification would entail Roman 2 to my role comes into once the division happens, the tainted goes out of the system, and the system provides for 1.1 to 1.4. So for one vacancy, 10 people, a list of 14 will come. If a list of 14 comes, and in the list of 14, there are tainted and untainted. I am not in that list. My mark is below that. Say for example, I am 16, 17 and 20, and not within the first 14. And it is found out within the first 14, 7 are tainted, and the segregation can happen. So I automatically, the category of marks will go down, and I automatically come in. Technically, yes. I absolutely understand. The situation is such that there is a possibility of a segregation, and if that happens, once the SSC has applied Rule 17, they have technically set the clock back.
Furthermore, the untainted candidate who worked for 6 years
the OMR sheets were never published. It is something where, my lord, something goes to the root of the matter. Where what is it that we are looking at which says that there is a manipulation and that the marks have been manipulated? Absolutely nothing is made available. During the process of proceeding before the High Court, inspection was made available for a limited time of 1 day or 2 days. So some persons took inspection of that. That's one, my lord. Therefore, when there is no publication of the so-called, my lords, OMR sheets, from where does all of this come? Second, my lords, admittedly, there is a criminal prosecution which is launched, which is pending consideration, pending adjudication. It is one thing to say the standard of proof in criminal proceedings is higher and therefore whatever may be the result. But the substratum for both, my lords, is the so-called manipulation, my lords, in the mark sheet, OMR sheets. If that be so, please see the anomalous consequence if that results in no conviction at all, or for that matter, no evidence is given by the so-called but so many other such consequences. That's the second point, my lords. Third, on 65B, my lords have again and again pointed out, I quite see the force of it, saying that it is only a certificate of the fact that it's a printout from the system. That's fine, my lords. What evidence is I want something more fundamental. Now, it is not the hardest from which the original stands are available. That's the second is not there. Which has been from a private person who was an ex-employee of and the manner in which this has become available to is completely suspicious circumstances. If that be so, my lords, can it stand to reason that on this basis, penalty, my lords, of removal from service can be done? And of course, the fourth aspect of
item number 1.27.
At page 1014 of the compilation, here, my lord, these were produced. and kindly sees what was the reaction and what was the direction which has not been followed by the citizen. Kindly comes to 1014. This is the recording of submissions
supervision of Shri so and so, Hiladi Das.
Let's go with the rest. Kindly come to 5 such originals when applicant also submitted the original electronic devices process he submits that the CBI intends to place those electronic devices in CFSL Kolkata for necessary processing. He seeks direction to the board regarding the production of original electronic devices. Now, can you see the direction which has been given by the Honorable Judge 1016? Last paragraph. So far as the aware of the Deputy Solicitor General is concerned, with regard to the original electronic devices are concerned, it will be appropriate to permit the CBI to produce such originals, which is CFSL Kolkata, where they propose to submit the same for necessary processing. As of today, there is nothing on record as to what is the result of CFSL Kolkata. It is not there on record. Second is, Mr. That is, my lord, the direction. Kindly comes to 1018. The original electronic devices are produced by the CBI pursuant to the order passed by the Honorable Court. Such original devices are required to send to CFSL. This is CFSL Kolkata. There is a criminal proceedings pending. According to CBI, those electronic devices are required for such criminal trial also. In these circumstances, we deem it appropriate to report that the original electronic devices are produced in seal cover. They are returned to the Deputy Solicitor General with the direction upon the CBI.
Now, Pankaj Bansal of electronic time was not the employee of NASA. He had left NASA and was taken over by the supervisor.
On the basis of which allegedly the OMRs have been retrieved from these hard disks. These were the only materials.
Now, where does this go? Kindly just produced on the basis of
Lordship, there is a distinction. Lordship, in 1.37, there were orders by the High Court, and this is 1.37 in volume 2, that is annexure B1. So there was one question which was very answered, re-examined by the High Court, and our answers were found to be correct. So after the School Selection Commission and also the single bench, we were genuinely appointed. So our appointment has been also cancelled by virtue of the impugned order, which is because a few candidates or 8,000 candidates were found to be illegal appointees. We were genuine appointees, Your Lordship. It is mentioned by the single judge's order in volume 2 at page 45 to 448, 445 to 442, 445 to 442. If I can just read that one paragraph of 445, the petitioners were the aspirants and participated in the first level selection process 2016 with the post of assistant teacher history. The final certificate was published on March 12, 2018. Subsequently, pursuant to a direction made by a coordinate bench, the West Bengal Central School Service Commission had published the OMR answer sheet of the aspirants on their official website. From such publication, it appears that the petition.
All the data, it said most data was had. You are calling the sound.
Different allegations. In group D, they say that as published.
No, all that data was handed over.
Word revision by candidates
The West Bengal Central School Service Commission had published the OMR answer sheet of the aspirants on their official website.
Even then, 31 candidates like this panel, I just come to para, 31 candidates. So there are 3 separate categories. My submission to your lordship, please.
No, lordship, it is, I represent 27. So I
Item 1.3, I represent the OMR by regulatory.
said order dated January
I'm not like this.
2023 stands
List of
corrected and
907,
clarified.
the two
Now
additional
coming to the
OMR
point
is
in
not
which
available
this
as
is,
far as 11th.
Two of the three
got
categories.
equal petitioners before the single judge, and we got appointed by the orders of the court.
These two issues.
Notably, the CBI had filed an investigation. Very important.
No, not just because. Omnibus submission.
Saying that the totally unchanged relating to all
There is a blanket order by the High Court. I should
category as far as the High Court has recognized that OMR as a table. Your worship has heard the OMR manipulation issue. Your worship has heard the OMR issue. May I just point out two more things? Rank jumping first, 94. My lord has heard expiry of panel, and my lord has heard beyond the advertised post.
No, but all your lordships will ever see is
For the untainted category of assistant
teachers. No, no, and the
We
other thing,
represent 10,160.
No, no,
Now, here, I want to invite the
paragraph
240
they applied for these exams for upgradation.
which your lordship
There
will
was
find
no
at
other
page
information
216.
Third aspect was
It's only the High Court
much
will
more
have
given
nowhere have I been
relaxation.
touched. Now, the High Court itself records that in assistant teachers that from last 9 to 10 levels, alleged irregularity is 40.5%. And as far as classes 11 and 12 are concerned, 14.47%. So obviously the group which I represent is part of that untainted category.
Allegation. It's the allegation. Now, may I submit?
Your lordship will
Yes.
and to confine the operative cannot, in my respectful submission, 10,000 teachers over here, each one in harness, nothing found marks have been altered, otherwise throw them all out with this kind of a percentage. Therefore, your lordship will provide guidance in two judgments. So I'm just going to give your lordship the citations. They are in my respectful submission. The first is Indrapreet Singh Alon. Yes, you can refer to 2006.
If very well they check my papers and they find yes, I see.
41 is the most important, but there are other paras also. And the second, Omkar Lal Bajaj. There was 24 across the list provided by CBI and the court.
Where the relevant paras are paras 44 to 46. Now let me just summarize what we have on our the first point in our respective decision as far as Kanun is concerned, where all the judicial appointments of 336 interfere and reverse. Because you can't have, because the principle is laid down work. There had been no basis where people haven't passed or are so if you have 10,000 unemployed, where is the question of candidacy? Now, therefore, this is what the laid out if you have situations where people are already employed, para 41, then you have to see sufficiency of evidence. So it's an addition, there's no evidence at all. The OMR arguments are all different arguments. Those are also not about all. There is absolutely no evidence for the High Court. Now, if you have no material for the High Court, and situations such as you find that in some cases there is some people have been from other situations, some panels, some OMR were not found. Then the final all are confined to those types of cases alone. And Omkar Bajaj, your lordship,
according to the sheets,
petrol pumps were set aside. And this court said that
submission before the High Court.
You are here, fortunately, you have an
You have
to remedy that. The remedy has to be tailored to the situation wrong. You can't have a situation which is worse than the problem which the court was encountering. So this, my lord, is my first set of submissions. The second set of submissions, my lord, which I mentioned, is another fundamental principle. I just state the principle. Your lordships have heard us. The principle is essentially this, that under our system, if you are losing, my lord, your jobs, then I believe we are entitled to one right of appeal, which is why your lordship is very good. Now, on this aspect of appeal, I want to give your lordship 4 or 5 dates.
This is my
Just hand it over. Now, this is, my lord, I am now not on assistant teacher. This is the second set. I'm just going to give you 5 dates. On one
aspect alone, because this group which I represent, which is UMC candidates which are non-teaching staff, although successful, they have been branded as having been appointed after the expiry of the panel. Correct? So I'm just making my suggestion. Please just go to paragraph 6.
For the very simple reason that he does not.
In particular, the finding of the petitioner's appointment were after expiry of the panel is erroneous. The panel is defined in section 2F of the 2009 rules. In the present case, the panel was declared. Now note this date on 20th June 2019. This is the first date when the candidates with all their particulars were ranked, and a list was published region-wide, and illustrative extract of the panel is